I want to thank everybody. I want to thank everybody in the audience today for our tech issues. It may be a password issue. Has anybody ever had that before? So the subcommittee on new offenses and change penalties will come to order. The clerk will call the roll.
Chair Lauterbach,
Here.
Representative Moody, Representative Bowers, Representative Little, Representative Money.
Quorum is present. As a reminder, anyone present wishing to testify before the committee, please register at the kiosk located in the hallways behind the hearing rooms. If you require assistance in registering or testifying, please contact the committee staff. For our witness testimony, when you're called to testify, please make sure to state your name, who you are representing, and your position on the bill. Please be respectful of others' time and keep your testimony to the 3-minute time frame. The timer will be here, and we'll manage it from up here. Recognizing Representative Money arriving. Finally, per House procedural rules, witness testimony must be limited to the bill or resolution currently being considered by the committee. Please make sure to keep your remarks to the subject matter of the bill. With that, we will begin. Yeah. The chair lays out House Bill 1414, Representative Bowers to explain the bill. Representative Bowers is present.
Thank you, sir. Thank you, Mr. Chairman, and thank you, Mr. Chairman and the committee, for hearing House Bill 1414 by Representative Dr. Alma Allen, and I am here to lay this bill out for her. Currently, driving while license invalid, DWLI, a suspended license, is a fine-only Class C misdemeanor unless it is a person's subsequent offense, in which case it becomes a Class B misdemeanor, warranting up to 6 months in jail and a $2,000 fine. Tens of thousands of Texans are arrested and jailed each year for driving with a suspended license, some because they could not afford expensive civil surcharges. HB 1414 eliminates the enhancement to Class B misdemeanor for DWLI if the person has previously been convicted of a DWLL. Eliminating this enhancement will allow county courts to focus on more serious offenses and will prevent Texans from accumulating debt and criminal penalties that keep them from achieving financial security. This bill will allow county courts to focus on more serious offenses and prevent Texans from accumulating debt and criminal penalties that keep them from achieving financial security. HB 1414 does not eliminate the enhancement to a Class B misdemeanor on subsequent DWLI offenses, remains for those whose license has previously been suspended for a driving while intoxicated offense. On its own, driving with an invalid driver's license, DWLI, is a fine-only Class C misdemeanor offense. However, state law provides for the enhancement of the penalty for this offense to be a Class B misdemeanor, warranting up to 6 months in jail and a $2,000 fine under certain circumstances. According to the data for the Department of Public Safety, thousands of Texans are arrested and jailed each year for a DWLI, some because they could not afford expensive surcharges based on minor driving left infractions. Not only is this detrimental to the individuals sentenced to jail time, but taxpayers are also left footing the bill. HB 769 seeks to eliminate the Class B misdemeanor, and I think that should be 1414. So let me back up. House Bill 1414 seeks to eliminate the Class B misdemeanor enhancement for DWLI to allow county courts to focus on more serious offenses and prevent Texans from accumulating debt and criminal penalties that keep them from achieving financial security. When we look at the criminal justice impact, it is the committee's opinion that this bill does not expressly create a criminal offense, increase the punishment for an existing criminal offense or category of offenses, or change the eligibility of a person for community supervision, parole, or mandatory supervision. And when we look at the rulemaking authority, it is the committee's opinion that this bill does not expressly grant any additional rulemaking authority to a state officer, a department, agency, or institution. And looking at the analysis, House Bill 1414 repeals Section 521.457 of the Transportation Code, which enhances the penalty for driving with an invalid driver's license or DWLI from a Class C to a Class B. And so with that, if there are no witnesses, I reserve my right to close.
Members, are there any questions for Representative Bowers? Seeing none, we acknowledge your right to close.
Thank you, sir.
The chair will call the first witness, Rylan Maksood. Rylan Maksood.
Good morning, Representatives. My name is Rylan Maksood. I'm an attorney with the Texas Fair Defense Project supporting HB 1414. If you pass this bill and reduce the penalty,
We show you registered as Rylan Maksood, representing Texas Fair Defense Project and yourself. Is that correct?
Yes, Chairman.
Okay, thank you. You may
Thank you.
proceed.
If you pass this bill and reduce the penalty for subsequent driving with an invalid license from a Class B to Class C misdemeanor, Texans who cannot afford to restore their licenses but drive will still be subject to arrest, vehicle impoundment, days of jail time, a mandatory 90-day license suspension extension, and a 2-year conditional suspension of both their license and vehicle registration unless they can afford to purchase an SR22, a much more expensive form of car insurance. The only difference is that our neighbors who cannot afford to restore their licenses and must drive to provide for their family, disproportionately rural Texans, will face only days of jail time instead of 180 days. This 22-page chart from DPS with about 7 rows per page is a list of all the ways your license can be lawfully suspended, and I can't even staple it. I've also seen a number of unlawful suspensions, with DPS still not complying with laws you passed last session. But the vast, vast majority of the hundreds of thousands of invalid licenses come from poverty. Folks unable to afford insurance and folks indefinitely denied renewal by the Omnibus program for not being able to pay traffic citations they've received. Indigency waivers for citations are totally discretionary and used less than 2% of the time, and there is no possibility of waiver for the $200 in DPS reinstatement fees. The only 2 other avenues to an invalid license with any significant use are indefinite suspensions until civil judgments are paid, a form of debtor's prison, and DWI suspensions. And this bill keeps it a Class B misdemeanor for anyone who's ever gotten a DWI, and a Class A for anyone who causes a serious accident. Although this bill will not solve our debtor's prison problem, which our state constitution explicitly prohibits, it will reduce the number of days debtors spend in jail. With this change, since they cannot afford to pay fines and costs, they will face about 4 days in jail at a rate of $150 a day to fulfill what they owe each time they are caught driving with an invalid license, in addition to the days or weeks in jail from all the other citations they've been unable to pay. I think that's a sufficient deterrent and punishment. I've seen a JP start her docket by angrily, preemptively declaring that she does not care if you had to drive to get food for your baby. And I hope you agree 6 months in jail for that crime is excessive. Thank you, and I'm always available for any questions.
Thank you, Mr. Maksood. Are there any questions? Representative Money?
I'm interested in this because I was previously a part-time municipal lawyer. I've dealt with a lot of these cases. A lot of them are very sad and difficult. and so there's parts of what you said that compel me a bit. But here's the reality is that even, and especially in rural Texas, where I'm from, you don't have to drive. And if you do drive without license or almost always insurance, and you plow into my family and leave me with a wrecked car, injured, or even worse, family members, there's no recourse for that for me civilly. And so I think saying that this is a debtor's prison issue is hyperbole. I understand where you're going with that, but it's when you break the law and you get a citation for driving with a license invalid, and then you continue to drive with a license invalid again and again, and you get additional. Eventually, doesn't there have to be a mechanism in the law to raise the stakes so that people will stop driving without a valid license, without insurance, according to the laws? There may need to be an adjustment to the way this program is. The surcharges I have some real problems with. But when you're talking about just people continually, intentionally violating the law, not getting someone else to drive them, pick them up, Uber, even in our small town, we have a form of public transportation that you can plan ahead. Very small towns are usually walkable. I think I don't think this is the right fix.
May I respond?
Yeah.
First, one can obtain insurance with a invalid license, and I do have a number of clients who do get insurance, but they just can't afford. All the money goes to insurance. They can't afford to restore their license. And it's my opinion that the days and oftentimes weeks in jail that they're subject to is a sufficient punishment to incentivize them to pay to restore their license. Ultimately, if they have insurance with a suspended license, it's just a matter of how much they owe the state. And certainly I don't think that folks shouldn't pay if they can pay, but I've never seen someone simply refuse to pay and choose to face weeks of jail time, at least in my experience.
I understand the idea that some people cannot pay. And that's a horrible situation. Like I said, I've sat eye to eye and face to face with lots of these people. I feel very, 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 very hard for. But I also have to think about the other people out there that are following the law and are endangered by somebody who is driving without a valid license, and who are not deterred sufficiently, even by our current laws, to stop driving without an invalid license. And so, if there needs to be a broader discussion about whether we need driver's license, how much that should cost to obtain, again, the surcharges, I think it's fine. I don't think that eliminating a criminal offense enhancement is the proper fix for that.
Thank you.
Any other questions for the committee? Seeing none, thank you.
Thank you.
The chair calls Jennifer Carrion. Thank you, Ms. Carrion. Please state your name for us, who you represent, whether you're on, for, or against the bill.
Thank you, Chairman Lauterbach. Good afternoon, members of the committee. My name is Dr. Jennifer Carrion. I'm the director of the Criminal Justice Project with Texas Appleseed, and I'm testifying in support of HB 1414. I do, if you'll permit me, Representative Money, would like to address your concerns after I provide my testimony. For the past 7 years, our project has researched and analyzed data associated with the state's failure to appear, failure to pay program, which allows JP and municipal courts to place a renewal hold on driver's licenses if someone fails to appear or pay the debt associated with their traffic tickets in full. The structure and application of this program is what's known as a debt-based driver restriction strategy. In our continued study of it, we've encountered numerous Texans who have explained how a minor traffic ticket has spiraled out into a mountain of debt that is now tied to the legality of the very thing they need to make that money to pay that debt back, a valid driver's license. As you can imagine, the strain associated with lingering legal debt coupled with the stress of having to get to and from work or get the kids to and from school without a valid license is not easy to escape. And yet, what is one to do when the money does not exist to dig yourself out of that hole? Currently, over 402,000 Texans have expired licenses that are ineligible for renewal due to the holds allowed by the state's FTAP program, or what the former witness referred to as the Omnibase program. This number does not include Texans who have had their licenses revoked or suspended due to drunk or reckless driving, or even those who qualify as habitual violators. What we are talking about is people who have received maybe 1 or 2 traffic tickets you either could not or forgot to pay, and the fines associated with those late penalties, warrants, CAPE processing fees have just piled up. These are Texans who would benefit from this bill being passed. Every day, these Texans get behind the wheel and are subjected to being pushed further into the system. Removing this enhancement ensures that people who would otherwise be categorized as having no to low risk of reoffending are not exposed and intermingled with those who are high risk of or potentially violent. It saves time and resources for law enforcement, local jails, DAs, and county courts. For the components of our justice system to be effective and efficient, limitations and capacity need to be acknowledged, and matters that are overburdensome, taxing, and distract from the ultimate goal of securing our communities from actual threats to public safety should be alternatively managed and contractually minimalized. As our community systems and state continue to recover from the economic and employment fallout associated with the pandemic and fluctuations in federal aid, we should strive to pass legislation that helps get Texans back to work, back on the road and back to work. Passing a bill like HB 1414 gets us closer to that goal, as it removes a barrier within the system's control that is negatively impacting hundreds of thousands of Texans. I thank you for your time and consideration, and I'd like to take any questions. Representative Money.
You heard my other question. I won't repeat it, but my
Representative Money.
I'm sorry.
Recognize Representative Money for question. Thank you.
Thank you, Chairman Louderback.
I'm sorry, Mr. Chairman. You heard
Somebody has to.
my previous
Yes, sir.
concerns. I do have concerns with the financially punitive
Right.
system that we have, but I don't think that removing this enhancement directly addresses that problem, and I don't like this approach of fixing it. But I'm open to hearing what you have to say.
Yeah, so we're talking about, we're getting 402,000 people sitting there who first time around Class C, second time around it's Class B, and now they're facing up to $2,000, 180 days in jail time. These are people who are not high-risk offenders. The situation that you spoke of earlier, there is plenty of recourse for that individual to be held accountable for the actions of their crime, if you will. If someone T-boned you and slammed into your family because they have a second DWLI, I'm not getting them from that. I'm getting them for reckless driving. I'm throwing them in jail for longer than that, right? This is not that. This is making sure that the people who don't have the money to pay on their licenses aren't subject to time in jail. You know as well as anyone, whenever you have a Class C misdemeanor, it's a fine-only offense, you're not subject to counsel. And so what are you supposed to do? You're just getting railed over and over again with the system by finances that you don't have the money to pay. And instead of reaching for alternatives that we currently have legally to adjust the fines and the penalties, what we do is continue to subject these people to the system. When we have law enforcement that are having trouble filling their positions and having trouble focusing on clearance rates for violence crimes. We have county courts that have backlogs that they can't get to. DAs that would rather be focusing on violent crimes on the T-bone rather than the mom who got caught the second time around driving her kid to work. That is what this bill does. And the 70-page or whatever page number, your DWI multiple habitual violators, guess what? They're in there too. And they can get their license taken away from them too. So we have ways to deal with those, Representative Money, but this right here is creating problems for a lot of people. And I would love to work with you on the fines and the fees things for sure, because you know more than anyone that that's hurting a lot of Texans. So,
Thank you. Do we have any other questions? Seeing none, thank you.
thank you so much, Chairman Lebeck.
The chair now calls Sarah Reyes. Thank you for being here today, Ms. Reyes. We show you registered for the Texas Center for Justice and Equity and yourself. And are you on for or against the House Bill 1414?
For the bill.
For the
sir.
bill.
Yes, sir.
Thank you. Go ahead.
Yes. Awesome. Good afternoon, Chairman and members of the committee. Thank you for the opportunity to speak today. My name is Sarah Reyes. I'm the Youth Justice Policy Director for the Texas Center for Justice and Equity. I'm here to express my support for HB 1414. Too many Texans face license suspension simply because they can't afford a fine, putting them in an impossible position. By making DWLI a fine-only offense, this bill ensures that Texans are not jailed or burdened with a criminal record for what is ultimately an administrative issue. Research from the Texas Office of Court Administration shows that 75% of individuals with suspended licenses continue to drive, and 87% of the DWLI cases stem from financial instability, not safety violations. The reality is that that jailable offenses do not deter people from driving without a license when their survival depends on it. If the goal is to ensure compliance, we must remove the punitive options and not criminalize those who cannot afford to overcome them. It is also important to recognize that jailing individuals for driving with an invalid license does nothing to solve the underlying reason why people continue to do so. The vast majority of these individuals do not repeatedly choose to disregard the law, but rather people who must drive to keep their jobs, take their children to school, or care for their families. Instead of addressing the root causes such as excessive fines, bureaucratic barriers to license reinstatement, and the lack of alternative transportation, our current system traps people in cycles of arrest, debt, and further license suspensions. Reducing this to a non-jailable offense addresses a big problem for repeat offenders, fostering compliance rather than perpetrating a cycle of legal and financial hardship. This bill also would allow for a more productive and cost-effective approach to this issue. Instead of counties wasting taxpayer dollars by penalizing individuals with incarcerations, we can redirect those resources towards educational and rehabilitation programs such as driver safety courses, legal assistance for resolving outstanding issues related to licensing, and financial support for low-income individuals to address the systemic barriers that often lead to license suspensions in the first place. Ultimately, this bill presents a pragmatic solution that balances public safety with the well-being of our communities, all while ensuring more efficient use of taxpayer dollars. It moves us closer to a more just and effective criminal justice system, one that addresses underlying issues and promotes long-term solutions. I urge this committee to support HB 1414 and help Texans build a more equitable and efficient Texas. Thank you for your time.
Thank you. Are there any questions for Ms. Reyes? Thank you. Seeing none, thank you for your
Thank you, sir.
testimony. That concludes the testimony for 1414. And we will. Yeah. So we will recognize Representative Bowers to close.
Thank you, Mr. Chairman, and thank you, committee, again. Thank you, Representative Money. I will let that Representative Allen know that you've got some questions about this bill. But I believe HB 1414 eliminates the enhancement to a Class B misdemeanor for DWLI if the person has been previously convicted of that. And I will ask her to circle back with you at a later time. Thank you so much, and I close.
Thank you. We will leave House Bill 1414 pending. Number 2. The chair lays out House Bill 316, HB 316, for Representative Perez. Thank you.
Thank you, Chairman Lauterbach and members of the committee. I appreciate you allowing me to lay out House Bill 316. House Bill 316 creates a criminal offense for interfering with or manipulating a gas pump payment terminal or metering device. During the 87th legislative session, we passed House Bill 2106, which transferred rulemaking authority for card skimmers at gas pumps to the Texas Department of Licensing and Regulation. And we established the first Financial Crimes Intelligence Center in Texas in order to coordinate law enforcement efforts. The center officially opened in January 2022, and according to the FCIC 2024 annual report, the total amount of loss prevented or recovered is nearly $300 million. The center started with card skimming at gas pumps and began receiving cases that involved ATM skimming, ATM malware attacks, point-of-sale skimming, organized check forgery, identity theft related to automobile loan fraud, and other related crimes. In April 2022, the center began seeing a new trend in financial crimes, which is large-scale fuel thefts. It was found that these crimes were being committed by the same organized groups that were committing card skimming at gas pumps. The money laundering portion of card skimming at gas pumps shifted from gift cards to stealing fuel. The goal for these criminal groups became obtaining fuel, so they no longer needed gift cards. Now, devices that manipulate the gas pump's metering device are installed so that the amount of fuel being dispensed by the pump is no longer accurately being measured, therefore allowing criminals to obtain several hundred gallons of fuel at a time for only a few dollars. This bill seeks to prevent criminals from tampering with the payment terminals and metering devices at gas pumps. Texas has taken the lead on tackling organized financial crimes. HB 316 builds upon our work from the last 3 sessions so that Texans can continue to be a model for other states. With us here today, we have Captain Jeff Headley with the Financial Crimes Intelligence Center to speak in favor of the bill and answer any questions you may have. And with that, Mr. Chairman, I respectfully request the right to close.
Thank you, Mr. Chairman. In the bottom half of this bill, the first half adds the offense of interference with motor fuel metering device or motor fuel unattended payment terminal. But then section 2 eliminates 5B. And I'm trying to figure out what that has to do with section 1. I'm looking at it on Cap Central.
Right. Where it omits any unlawful possessions?
Yes.
Is that it? I don't know off the top of my head.
Okay.
Actually, Captain Healy should be able to answer that question for you.
Who should?
Captain Jeff Headley.
Okay.
He's with the Financial Crimes Intelligence Center, and they actually helped write the bill.
Okay. And is he one of our witnesses? Okay.
he is.
All right. Well, thank you very much. Appreciate it.
Any other questions for Representative Perez? Seeing none, we'll call our first witness. Jeff Headley.
Mr. Chairman, real quick, can I just say something?
Go ahead.
Just in general, if you're here to testify, and I know this is a bill that's creating a new offense, as you lay out testimony, touch on the exact gap in the law that's not being covered. We have a myriad of penalties and penal code provisions and punitive provisions across different codes. So I really want to zero in on the gap that we're filling that doesn't exist now. If we're just trying to create something that is essentially a stealth enhancement, that's something that I want to kind of ferret out. I'm not saying that's what this bill is about. I'm just saying generally to folks, I think it'd be helpful for this subcommittee, since that's kind of our charge, is to, if we're creating new offenses, we kind of need to know what gap we're filling. So I didn't mean to step on your testimony, sir. I apologize. I just generally, it's something I'm going to be curious about no matter what bill comes up. So thank you.
Thank you, Captain Headley. Please state your name, show what you're registered as, and who you represent, and also if you're for the bill or against the bill.
Good morning, Chairman Louderback and honorable members of the Criminal Jurisprudence Committee. My name is Jeff Headley, and I am here today as a captain with the Texas Financial Crimes Intelligence Center, otherwise known as the FCIC. I'm grateful for the opportunity to testify in support of House Bill 316, authored by Representative Marianne Perez, which addresses the growing threat of interference of motor fuel metering devices and unattended payment terminals. The Texas FCIC is dedicated to identifying, preventing, and combating financial crimes that harm our communities and economy. House Bill 316 aligns directly with our mission by establishing a robust framework to deter and prosecute a sophisticated form of crime, tampering with fuel metering devices and payment systems. These acts are not mere vandalism. They are deliberate schemes designed to defraud consumers, businesses, and the state, often orchestrated by organized criminal networks. This bill creates a new offense under Section 16.021 of the Texas Penal Code, making it a second-degree felony to interfere with motor fuel metering devices or unattended payment terminals, manufacture or sell manipulation devices, or knowingly benefit from such activities. By classifying this as a felony, House Bill 316 sends a clear message. Texas will not tolerate exploitation that undermines trust in our fuel distribution systems. The financial impact of these crimes is substantial. For example, one fuel provider chain lost over $90 million in fuel in 2023 due to this type of crime. Tampering with metering devices, often through the use of motor fuel manipulation devices, allows perpetrators to siphon fuel illicitly, evading taxes, and depriving legitimate businesses of revenue. This not only drives up costs for law-abiding Texans, but also funds further criminal enterprises. The Texas FCIC has observed a troubling rise in such activities, often linked to broader organized crime networks, which this bill smartly addresses by amending Section 71.02 of the Texas Penal Code to include these offenses as predicates for prosecuting organized criminal activity. Beyond the economic toll, these crimes pose a public safety risk. Manipulation of the fuel pumps can deliver inaccurate volumes, leaving consumers vulnerable to fraud. And in some cases, compromised systems may fail to meet safety standards in those fuel pumps. House Bill 316 provides law enforcement and prosecutors with the tools to hold offenders accountable while protecting exemptions for legitimate technicians and regulators, ensuring that the law targets only bad actors. In conclusion, the Texas Financial Crimes Intelligence Center wholeheartedly supports House Bill 316. It is a forward-thinking measure that safeguards our economy, protects consumers, and reinforces Texas' commitment to combating financial crime and fraud. I urge this committee to advance this bill and thank Representative Perez for her leadership on this issue. And I'm happy to answer any questions she might have.
Thank you.
Go ahead, sir.
One piece you need to clear up. You're a state agency, so you're neutral on the bill, is that correct?
We're actually in favor of this bill, sir. It's one that we brought to Representative Perez to help us combat the crime.
I think you'll be testifying just on the bill.
Yes, sir, testifying on the bill.
Thank
Yes,
you.
sir.
Thank you. Members, any questions? Representative Money.
Thank you, Mr. Chairman. Can you explain what Section 2 of this bill does?
I was looking at that Section 2, and I think it really is just a matter of cleaning up some of the issues on the bill dealing with the occupations code on the technicians. And it was a request that was put into bill for that. And to be honest with you, it would probably be better to have somebody from the Food and Fuel Administration speak more to that matter.
Okay. Yeah, it doesn't look like it's coming from the occupations code. It looks like it's from, hold on just a second. Chapter 71 of the Penal Code, organized crime, engaging in organized criminal activity.
Oh, I apologize to you, Representative Money. On what that speaks to is simply making it to where we can utilize this crime as a predicate offense for engaging this activity in organized crime.
Okay, and I love that. That sounds good, but it crosses through 5B, unlawful possession with intent to deliver a controlled substance or dangerous drug. Unlawful possession with intent to deliver controlled substance listed in penalty group 1B under section 481-1022 Health and Safety Code. And so that's the part that's confusing me is why are we removing certain drug offenses from the organized crime code as a part of this bill?
That would be something that honestly, sir, would not be something that the Texas Financial Crimes Intelligence Center would be in support of or against. It's not something that we would have brought forth in this, sir.
Okay. All right. Thank you.
Thank you.
One question, Captain. What's the penalty going to be for this?
It'd be a second-degree felony, sir, which matches a law dealing with tax evasion at the fuel pumps, which is usually one that is brought forth and investigated by the Comptroller's Office for the evasion of fuel tax. So it's currently a crime that we have used in prior prosecution of these fuel cases, but it's also one that only a limited number of investigators can file in the state of Texas. This would broaden it out to where more of the sheriffs, more of the police departments, and more investigators in the state would have more readily be available to prosecute these crimes quickly.
And this is brought about, is it not simply that the cartel is stealing a lot of fuel?
Sir, it's not necessarily cartel connected, although we know that some of the individuals that are involved in stealing fuel are using this to power vehicles and transportation trucks that are actually involved with some of the trafficking that is going on. Yes, sir. So although the groups that are involved specifically in stealing the fuel tend to be largely Cuban organized crime related groups that we're working, that is not necessarily to say that they are all cartel connected, although we have found some connections in our cases.
Thank you.
Thank you.
Members, are there any other questions? For Captain Ely? Thank you, sir.
Thank you very much.
And seeing no other witnesses, Representative Perez would like to close on the bill.
Thank you, Mr. Chairman. Thank you for your time. I would greatly appreciate your favorable consideration. And with that, Mr. Chairman, I close.
Thank you. If there's no objection, the bill will be left pending. The chair hears none. House Bill 316 will be left pending. Thank you. Let's see. The chair now lays out House Bill 353 with Chair Patterson presenting the bill. Thank you.
Thank you, Mr. Chairman, Sheriff, Representative, sir. I don't know what to call you. Mr. Chairman will work. Chair Louderback, members of the committee, I want to thank you for the opportunity to lay out this bill, House Bill 353 today. In 2022, I became aware of a concerning issue where an individual would sit in a lawn chair and watch children when they were outside playing on the playground at their daycare center. Because this individual was not on the daycare center's property, the daycare was unable to ask him to leave. Instead, they prevented the children from going out on the playground on multiple occasions when the man was in the area, as they had concerns for their safety. The police were involved in this case multiple times, but as this occurred off the daycare's property, despite being just a few yards away, they apparently had no ability under current statute to stop this man from causing concern at the daycare. Last session, this bill was filed by HB 2962. Representative Kronda Timish, Representative Little now represents this district. We split the colony where the person who brought this bill forward serves on the city council. That bill went through the Youth Health and Safety Select Committee, where some of the members had questions about this legislation. Over the interim, I have worked with members who expressed concerns and believe that HB 353 has addressed those concerns. This bill creates a Class A misdemeanor for anyone who enters or remains on a school's or daycare's property or within 250 feet of those facilities and either poses a substantial risk of harm or on multiple occasions has behaved in a way that would be considered inappropriate for a school or daycare setting. Additionally, the offender would have to receive a request from an administrator, educator, or security personnel officer to leave and refuse to leave. There are many individuals here today who can speak directly on similar issues that have occurred across the state, and I'm saddened to hear of the relevance of this issue, but look forward to addressing the concerns this session. I want to thank in particular Councilwoman Robin Holtz, who is here from the Colony, Texas, which I share with Representative Little, who is here, who brought this idea forward last session and again this session. And with that, I'd be happy to answer any questions that you all have.
Questions from the committee? Seeing none, Chris, you're right to close.
Yes, sir. Thank you.
Okay, thank you. The chair calls Robin Holtz. Ms. Holtz, we show you registered as Robin Holtz. Are you testifying on, for, or against the bill?
For.
Okay, and you represent,
I am representing myself as Representative Patterson mentioned. I am on City Council in the Colony, but this is not on behalf of City Council. This is just me as a mom here today. And I appreciate all of you committee and state reps for hearing this bill today very much.
well, thank you. We'll show you registered for self.
Self.
Go ahead.
Okay. Committee, a few years ago, as State Representative Patterson mentioned, I enrolled my children in a daycare that I did extensive research on to make sure it was the best daycare that was safe for my children. Upon taking them to daycare and doing their regular drop-offs or pickups for doctor's appointments, I would go around through the back of the building where the playground is because it's a shorter route sometimes for me, and I would notice a man hanging out by the playground while the kids were out there. I became very concerned because this has happened. I saw it a couple of times, and I was asking the school, hey, there's a large man that could overpower those teachers, and he's very close to the children. Can you ask him to leave? And the school was already aware of him. They said this had been ongoing and that they notify the police each time, but the police will no longer come out because he's not on school property and there's nothing they could do. I thought this can't be the law that we have, because by the time this man steps on the school property in the playground, it's going to be too late. There's 20 kids under the age of on this playground at any time, and there's one teacher at these daycare centers. The doors lock automatically. If this man crosses onto the playground, how is a teacher to get a door unlocked, 20 kids to safety, and notify authorities? To me, there's a gap in our law by saying, and I'm sorry, there is a gap in our law that says that a crime has to be committed on school property before we can ask someone to step away from the school. I researched it and I went online and I thought there's no way. I even called the police and asked myself, and they said, we're aware. If he steps on school property, please call us. This went on multiple times. I even asked the man if he needed assistance. Does he need to go somewhere? He likes that area. So I did research, and I found multiple other states that have a law in place that says you cannot be within a certain distance of school property without a lawful purpose. So basically it says if you're within, whether it's 250, 200 feet, you have to have a reason to be there. I thought why is Texas not doing this? Why are we not doing a better job of protecting our children? Our children are selfless. They're selfless. They can't take care of themselves. They don't know if danger is lurking. They're not paying attention like we do as parents when we're out with them. We need to give that barrier and give the power back to the school authorities. Real quickly, in DFW, the main concern lately has been among parents is the issue with child pornography, child abductions, and sex trafficking. My fear is that with this being an issue, we have seen other instances. Even a couple of weeks ago, I sent another video to State Representative to Jared Patterson, our state rep, of a different man. This has been multiple individuals. It was not just the one is how it started. There's been multiple individuals. The one most recently backed his car into the parking space by the playground, had his windows rolled down and his shirt off, and he was just sitting there watching the kids on the playground. I went in and notified the school this was going on. Again, he's not on school property. We can't do anything. The police can't do anything. With this issue taking a standard in our state with child crimes, it is awful. It is unacceptable. We should not allow people to have this close of a barrier to our children. They should have their own privacy and be able to play without the threat of someone videoing them or having unlawful thoughts or other intentions, and being able to case the school to see how to get in there or to see how to get the children. That we're giving them unlimited access to see how to commit a crime. It's unacceptable, and our state can do better, and our children are worth the fight for us to do this. Today I'm here as a mom of 3 under the age of 5. And when I'm at work, I just pray that God is watching them. I please encourage all of you to please give this bill a chance. Sorry.
Thank you.
Please
Thank
give
you.
this bill a chance.
Thank you for your testimony. Members, do we have any questions? Thank you very much. Appreciate it.
Thank you.
Number 2 is, okay. Chair now calls Astrid Domenico. We show you represented Astrid Domenico, and who do you represent?
Myself.
Okay, and you're on for or against the bill?
4.
For the bill. Thank you. Go ahead.
Hello and good morning. My name is Astrid Domenico. I live out in Manor. I've been in Texas for almost 10 years now, and I'm a parent of a St. Francis school student. My daughter, Ayelet, is 9 years old in the 4th grade there now. I want to say thank you to Representative Patterson for sponsoring, supporting this bill, and thank you all for hearing my story for just a minute. I had the experience last winter of driving my car away from what I believed was a school shooting. I drove away from what I thought was a school shooting because I had my daughter in the car with me. One morning at school drop-off, as my then 3rd grader was zipping up her winter coat, not 15 feet away from us, a man walked up to our school crosswalk, just ahead of me, just there, with a rifle strapped to his back, during school drop-off, where there were children, teachers, parents all around. He started waving at the school, just across the road, and then he started to cross towards the school. I drove away because I had my daughter in the car, and in that split second, it was either get her to safety and not help the unfolding situation, or stay and try to help, which I wanted to do, but put my daughter in danger. It was an excruciating decision. At the school, again, hundreds of people, but my daughter had seen this man too, right there in front of us with the gun. He was waving, he was walking towards the school, and she was very, very afraid. I called 911 and it rang and rang. I hung up and I tried again, and it rang and rang. Later, someone from 911 called me back. In the meantime, I had texted my partner in Manor, who is ex-Special Operations. He said, I'll be there in 5 minutes, although we live 15 minutes away. By then, I had found a policeman stationed at ACC, and I told him the story, and he said, yes, we know that guy. There's nothing we can do about him. He's not technically doing anything wrong. This man came back to our school several times more, always with the gun, always at drop-off or pickup. To say we were terrorized is the only right way to put it. Some parents kept their kids out of school day after day those weeks, and some, like myself, brought our kids to school, very worried that we were making a terrible decision. And then we stood outside for hours, patrolled the area ourselves, waiting in case he came back. I think of the teachers and the staff in those 2 weeks who had put on a brave face every day for the kids, and I think of those children so confused and afraid when school should be a place that they can trust. I hope that HB 353 stops bad guys like these from ever showing up at our schools and daycares. At the least, I believe it will equip the police to take the right action to better keep our schools and children safe. Please support HB 353. Thank you very much.
Thank you. Any questions? Members? See none. Thank you for your testimony.
Thank you for your time. Thank you.
Chair now calls Laura Colangelo. We show you registered as Laura Colangelo. Who you're representing?
The Executive Director of the Texas Private Schools Association.
Okay. Are you testifying on, for, or against?
For.
For the bill. Thank you. Go
Yes.
ahead.
Thank you. Sorry, I just ran, so I didn't have breath. There was a vote happening. My name is Laura Colangelo. I'm the Executive Director of the Texas Private Schools Association. I represent the 941 private accredited nonprofit schools in the state that enroll approximately 308,000 students. I'm here very much in favor of HB 353. Very grateful to Representative Patterson for this bill. I understand that this bill came from a situation in his district, but I can tell you this is a problem all over the state and the country as well, and it's not getting any better. You're hearing from parents who face a menacing situation outside of their private school here in Austin. Many parents all over the country are scared dropping their children off at school for unforeseen and unimaginable circumstances. Imagine having to drop your child off with what is appears to be an active threat right in front of you every day. So we did have a few suggestions to consider on the bill, although I know you've been working on this. That would be, the first would be to extend the perimeter around the property beyond the 250 feet if possible, but we will take what we can get. The second suggestion is to add to the phrase causes a disruption to the school learning environment to section 30.055B2A, which is the condition for the immediate removal, or perhaps to section B, remove the condition that the perpetrator must present this behavior on more than one occasion and pursuant to the same scheme or course of conduct. The purpose of this change is to allow the removal of people the first time they exhibit these threatening behaviors and, and are asked to leave, and not require repeated and similar incidents. Something to consider. We don't know the underlying cause of these terrifying incidents. Perhaps it's an increase in criminality on the street, more political anger, or the proliferation of mental illness in the society. However, it's our responsibility and highest calling to keep our children safe. This bill goes a long way to give schools and law enforcement the tools that they need, that they've lacked in the past to help protect these children, and parents and children all over the state will thank you. So thank you for your consideration.
Thank you. Members, any questions?
I do have, could I have written testimony? Should I pass that out? Is that okay?
Yes, certainly.
Okay.
Thank you.
Thank you.
Who's next? Chair calls Victoria Byrne. We show you registered as Victoria Lydia Byrne.
Correct.
Registered as self.
Yes, sir.
On, for, against the bill?
4.
Thank you. Go ahead.
Representative Patterson and esteemed committee, thank you very much for your time. My name is Victoria Byrne, Austin native, small business owner, and above all, proud mom here, in full support of House Bill 353. My daughter is a student at St. Francis. In November through December 2023, she was a kindergartner, just 5 years old, when Isaiah Smith took it upon himself to terrorize the faculty, families, and most heinously, the children of St. Francis. The kindergarten classrooms are on the first floor, with floor-to-ceiling windows directly facing the street. In an instant, the families of 30 children realized nothing but a pane of glass separated our kids from this threat. My daughter, who has since suffered night terrors, panic attacks, and anxiety, looked out of her window and saw the man with the pink hair and the guns walking right past her. I still have to occasionally pinky promise her that he's not going to come back. For 2 weeks, leading into the Christmas holidays in 2023, Mr. Smith terrorized our community. I was unable to leave my daughter at school. She was too afraid, and I temporarily closed my small business. Waves of panic calls and emails flooded our police, myself and others desperately seeking protection, yet APD indicated that Mr. Smith wasn't breaking any laws. In order to protect my child and my own sanity, our life was completely held hostage until Mr. Smith's indecency with the child charge surfaced. Later, we learned he had a total of 3 charges. Had HB 353 been in effect, our school would have been spared from this trauma. Some places in our great state of Texas are undoubtedly sacred, schools above all. Please pass HB 353 and help us to protect these sacred spaces. Thank you.
Members, question? Representative Moody?
Thank you so much. I
Chair Moody.
appreciate you being here. And I'm sorry, I'm looking at different things on this. The specific conduct that, who was it that told you that it wasn't an offense? Which agency?
APD.
APD.
Correct.
Okay. Describe the specific conduct one more time. What was happening with
So
this
we
guy?
had an individual who was essentially walking around the perimeter of our children's school with an AR-15, 2 handguns, and a GoPro attached to his chest twice a day for an extended period of time.
So school administrators called APD. Did they even come out?
They did. They did. Many times.
Did they visit with this
With the individual?
with this person?
As far as we know, yes.
And even after that interaction, kept coming back, doing
Yes,
the
sir.
same thing?
Yes, sir.
Did they convey to you, if anything, what he said his purpose was? What was he up to? Did they get any information from him?
So as far as my understanding, he was calling the school itself in the mornings prior to his parade and letting the school know that he was in support of the Second Amendment. And somehow this was a demonstration of sorts. But he waited for 8:15 school drop-off and 4 p.m. school pickup to demonstrate his cause.
Okay. No, sorry, I didn't mean to drill down that much. There is a provision of disorderly conduct that can be touched on here. I mean, obviously, it becomes a fact issue later down the road, but I mean, I do think in terms of the weapons portion of the conversation, there is a tool in the disorderly conduct statute. Of course, that may not be sufficient, but I'm just, like I said, I try to look to see where are other, because I know a lot of times you can have this happen either law enforcement side or the prosecutor. I used to be a prosecutor. Sometimes you'd say, I don't know if I'm able to get there, so we're just going to, we've done what we can and we're going to move on. Doesn't mean that it's not available, but it means that they don't think that there's, like, maybe it's not a path that could be successfully gone down. I mean, I would encourage in those situations that, I mean, maybe some better communication with APD, because I mean, I think based on what you've described to me today, I think they could absolutely charge with this. And is that charge going to stick? I don't know. I don't know, but certainly seems like a very scary situation. So
It absolutely
I
was.
appreciate your
Yes, sir.
testimony.
Thank you.
Thank you, Chair Moody. Any other questions from the committee? Seeing none, thank you for your testimony.
Thank you so much, everyone.
Chair now calls Dana Runloff.
Hello, my name is Dana Runloff.
Hold on,
and
just,
I'm.
hold on just a second.
I'm so sorry.
Ms. Runloff, you have registered twice.
My apologies.
Okay. Do we have your permission to remove one of those?
Yes, please.
Thank you.
This is my first time testifying.
Okay. And you represent
Myself.
yourself today. And are you testifying on, for, or against the bill?
I am testifying for the bill.
Thank you. Go ahead.
Hello, my name is Dana Runloff, and as I said, I'm giving testimony in support of HB 353. Thank you, Representative Patterson and the committee. I have 3 small children who go to St. Francis School. It's, as you heard, it's a small private school in north central Austin. In November and December of 2023, a terrifying situation occurred at my children's school, and I'm just going to give you a few more details about it. A man, Mr. Isaiah Smith, started walking outside of St. Francis repeatedly over a 2-week period. He had a long gun strapped to his back, and he had a camera on his chest. We did receive a call. We don't know if it was from Mr. Isaiah Smith, who said something about he was going to walk by the school. And as far as I know, that we received one call. He came to the school at least 5 times. He walked on sidewalks adjacent to our school within 50 feet of classroom windows, and on the school crosswalk during drop-off and pickup when there were hundreds of children and parents coming to and from the school. His threatening behavior scared our community, and we called the police repeatedly. They told us there was nothing that they could do. We had people calling every time he arrived. School administrators called, and we had a large community of parents who called APD, AISD-PD, the FBI, as well as state representatives, all seeking help. During those 2 weeks, my apologies. I also wanted to emphasize that our security guard engaged Mr. Smith. He told him that he was scaring people and scaring children, and he asked him to please stop coming to our school. However, Mr. Smith came back again. During those 2 weeks, it was agonizing as a parent to drop off my children, not knowing if they would be safe. Many days I missed work. I sat out in the parking lot just watching to see if Mr. Smith came back. My children were scared and confused, and during one terrible moment on the way to school, my 8-year-old asked me, "Mommy, what about if he starts coming towards us and he wants to do something bad? What do we do?" I had to take a moment to compose myself, and just remembering it now makes me feel emotional. I told my children as calmly as I could, "You know what to do. Run as fast as you can." That was the best I had to offer my kids at the time, to keep them home from school or to remind them to run if this man came after them. It was painfully inadequate. They deserved more. They, like all children, deserve to be safe and to feel safe at school. Mr. Smith was finally arrested on separate pending allegations of child indecency. I'm grateful this alleged child predator was arrested, because only then did he stop terrorizing our school. If HB 353 had been in effect, police could have arrested Mr. Smith for trespassing and spared my children and our school community a great deal of fear and anxiety. I support HB 353. Thank you again.
Thank you. Members, any questions?
I apologize. I don't want to drill down too far on this, but this is
Representative
the same situation we just talked about.
Yes, so
So-
you have multiple parents from St. Francis.
Okay, this is what I want to drill down on, because I don't think that was the right answer they gave you. I think they could have arrested this man. The testimony, or the comment that you said that your security person at the school talked to him and said, "You are scaring people, you're causing this effect here, we'd like you to no longer do that." That was information that was provided to him.
Mm-hmm.
People are scared here, your conduct doing this is scaring them.
Mm-hmm.
And he came back. That information was given to the police. Like, we have told him that this is what's happening here.
Yes. I'm a former attorney, and I've read the disorderly conduct statute, and I agree with you.
So right there, I mean, okay, on the first blush, I would agree with APD if they go up to him and he goes, "I'm just here demonstrating my rights." So I say, "Well, what's happening, sir, is you're causing there's a lot of panic going on in the school right now, and so that's the net effect of what you're doing. Not against your right to do what you want to do, but that's what's happening." Once he has that knowledge, then he comes back and does the same conduct. He absolutely is doing it with the intent to cause that effect, because he knows that's what it caused. Right there, I mean, that's the way I read it, but, I guess people could read it differently. Sorry, it's frustrating to me, because these pieces, now that the testimony's been laid out, to me, it seems like this person should have been arrested. But.
Could I respond? So although I completely agree with your instincts, all I can say is that we were desperate for help, and we reached out to anyone and everyone in law enforcement that we could, and we were repeatedly told that there was nothing that they could do. So, and that's why we're coming here to support this bill, because we don't want this to happen to us again or another school.
And I apologize. Don't take my questioning to say that I don't think you need this. my point, I'm sharing your frustration because I think in that I'm as a father of 3 young kiddos in schools that I leave back home in El Paso every week, and I think about these things. And I'm empathizing with that conversation that
Thank you
that
so
y'all
much.
have had.
Did anyone else have any questions?
Thank you. Do we have any other questions?
Thank you.
Thank you very much. Chair calls Travis Jordan. You're registered as Travis Jordan here.
That's correct.
Registered as, for yourself as a retired firefighter. And are you on, for, or against the bill?
I'm for the bill
Okay, thank you. Go ahead.
and representing my children and their safety. So I was going to say more, but I think our other parents have covered some of it. It's the same school, the same incident. And I believe that this bill would have given law enforcement better tools to help us deal with this situation. So,
Thank you.
thank you.
Any questions for this witness? Go ahead, Representative Bowers.
Thank you. With the severity of the instance, I just want to say thank you as a retired firefighter and as a parent for coming up and using your voice, but not repeating exactly what they said. I mean, really, we do feel you and hear what you're saying, so thank you for your testimony and
Okay.
those before you as well. Thank you.
Thank you.
Thank you. Okay, we're going to take a slight break for just a minute here to clear up a question. It's tough. I'll trade you. Call Travis Jordan. I'm sorry, we need to clarify who you're representing. Is it yourself?
Myself.
Okay,
And my kids.
Okay, well, it's got to be one or the other.
Myself.
Thank you, thank you. Appreciate you. Thank you. Okay, Madeline Green. Chair calls Madeline Green. Who's TCCB? I can find out from her. You're registered as Madeline Green with TCCB.
Yes, sir. Texas Catholic Conference of Bishops, for the bill.
Okay, your position is for the bill.
Yes, sir.
For Texas Catholic.
Conference.
She got it. All right, go ahead.
Thanks. Good afternoon, y'all. My name is Madeline Green. I'm a legal researcher for the Texas Catholic Conference of Bishops, testifying in support of House Bill 353. I'd like to share a different example to illustrate how this legislation can help us keep our students safe. In 2023, a man parked in front of one of our Catholic schools, St. Anthony's Basilica Cathedral School in Beaumont. The man was asked to leave several times, but he refused. He remained parked there for several days, and we, our staff, were very uncomfortable with his presence as he sat in his car staring into the front doors of our school every day for a couple of weeks. There was nothing that the police could do because this man was in a public space, so he did not have to comply with our request to leave. One of our nuns, Sister Virginia, literally sat outside monitoring the situation, and when he finally had a taillight out or some other minor infraction, that allowed police to ask him to step out of the car for a search. Police ended up finding his car filled with AK-47s and ammunition. Police arrested him and he was prosecuted, but this could have easily resulted in a tragedy. House Bill 353 would have been a solution to addressing this troubling situation on day one. Thus, we're in support of House Bill 353. Thank you.
Any questions for Ms. Green? Representative Money.
At what point I'm sorry about the whole story. I'm getting right into the questions. I've got small kids, and I can't imagine going through what all of you have gone through here. My wife has called me from the park before, like there's a weird man lurking about, that kind of stuff. I understand how concerning all those things are. I'm trying to decide, like, if this bill had already been passed, would you have known, and I'm focusing, you're not looking at the bill, did you know that he had weapons in the vehicle, or did you just know he was in the vehicle during the days that he sat there?
I'm not quite sure. I was actually finishing up law school when this
Okay.
happened, so
All
I
right.
wasn't on staff. But from what I heard, and it was extensively reported on, I think they were recovered later in the police search, but I could be wrong. I can follow up with that information.
Okay, and so I think specifically in this statute, and one of the requirements under Section B is that the person either poses a substantial risk of harm to any person, or that they behave in a manner that is inappropriate for school or daycare setting on more than one occasion. And so I'm just concerned that even if this had been passed, if he's just sitting in his car, got nowhere else to sit, I feel safe in front of a school, and I'm just sitting here, would that have been enough to have had him removed?
I'm not quite sure of the specifics, but I do know the gentleman was there for several weeks and every single day, and he was like watching and looking in the doors. So from his parked car right in front of the school. So I'm not quite sure what else fact-wise. But
Definitely disturbing, definitely concerning.
Sure.
God bless Sister Virginia and everyone else that stood there to keep the kids safe.
Yes, sir.
I'm just wondering if that would have risen to the level of posing a substantial risk of harm, or behaving in a manner that is inappropriate for school or daycare setting. Okay, well, what if he just sits and doesn't look in the door? You know what I'm saying? I'm trying to, I want to address the problem, but not create within the solution an obstacle that then makes it hard to fix the problem, so.
I know what you mean. I wish I had a little bit more information for you, but
No,
I
you
appreciate that.
You answered what I needed. Thank you very much.
Yes.
Any other questions, Ms. Green? Thank you.
Thank y'all.
Is there anyone else who wishes to testify on, for, or against House Bill 353? If not, the chair recognizes Chair Patterson to close.
Thank you, Mr. Chairman. As I think you can tell, there's a wide array of kind of different issues that this bill hopes to address. The bottom line is I think we need to provide more tools in the toolbox for law enforcement to not only engage with these people, but also give them the ability to ask them to leave. And that's what this bill hopes to address. If you guys have any, suggestions, I'd be more than happy to take those. And I'd be happy to answer any questions.
Representative Patterson.
Bowers.
Bowers.
Thank you, Mr. Chairman, and thank you, Representative Little, for letting me go, because I know you have a question too. So with all due respect to my chairman, Mr. Jared Patterson, thank you for this bill.
Thank you.
I'm a mom too, and we all know what concern we have for our children, and especially in our schools today. Could you clarify how this law would apply to public sidewalks and other public areas that happen to be within that 250 feet of a school? And then secondly, how this would affect normal public use of public spaces?
Absolutely, and that was a concern, I think, that was brought up in the Youth Health and Safety Committee last session. Let me see if I can find my answer to that on the committee sub-language, because we did change it. Oh, that's why, one of the reasons why we added the issue here around, basically having a talk first and then having to come back a second time and ask them, was just to make sure that we weren't doing a situation where we were profiling anyone or somebody's just walking their dog or anything like that, that someone that was not there for nefarious purposes wouldn't get caught up in this situation. So we added that kind of extra layer there. But it is within 250 feet of a school as it's currently drafted. And so that would be any property within 250 feet of the daycare or the school.
Okay, great. And I do recognize that your bill includes that 250 feet buffer zone. How can you explain the rationale for this distance? I think you just touched on it a bit, and how it would be practically enforced.
Do you mean like physically measuring, or well, I mean, I think we have a number of setback requirements in statute currently, whether it's a sexually oriented business or other things that we have in statute that may be more than 250 feet. This was the number that we chose based on conversations that we had with folks over the interim and throughout last session.
Okay. Well, thank you so much for this bill, and I look forward to signing on to it, and wish you great success with it.
Thank you,
you.
ma'am.
Chairman, do you have any other questions? Go ahead, Representative.
Yeah, thank you, Chairman Louderback. So Representative Patterson, the testimony was very compelling. I think you're trying to do an important thing here. I have some concerns about Section B2 of your bill, and it's not so much the content. My concern is that a lawyer is going to argue that it's unconstitutionally vague. And the concern that I have is it says that this person must either pose a substantial risk of harm to any person. I think I'm a little bit concerned about the presence of a firearm constituting that substantial risk and whether that's a slope we want to go down. But my bigger concern is with Section B. It says, on more than one occasion and pursuant to the same scheme or course of conduct behaves in a manner that is inappropriate for a school or daycare center setting. And my concern is without additional definition that somebody's going to say, how do we know what's inappropriate for that setting? How do we know that the behavior crosses the line without a clear standard? And so my concern is that this is going to be very difficult to enforce. I want to pose a question to you and maybe the other members of the subcommittee. If simply receiving a request to depart from that zone around the school from an administrator, educator, or security personnel officer should be sufficient to cause that person to leave, regardless of how they're acting, because I'm hearing these wonderful ladies and this gentleman tell their story about what they experienced, and the truth is that person was almost certainly lawfully carrying a firearm somewhere in public. And it's not that we want to illegalize that person carrying a firearm in public. It's that we just don't want them doing it right there in front of a school willy-nilly. And so I pose the question to you if maybe it is a better course of action to just simply empower those persons to require people to leave even if they're not on the school property, regardless of the condition they're in. And I don't know if anyone else sees the point that I'm making, but I have the concerns about the vagueness, because one educator could go, I don't like the T-shirt that person's wearing, I need them to leave, whereas someone else might have a more legitimate concern. And I leave it up to you and just share my concerns.
I appreciate that concern, and I don't necessarily disagree with your concerns there. This was kind of negotiated language that we had with the previous committee, that heard this, and working to find something that would work to solve this issue. if you have suggestions, certainly I'm wide open to that. If we can make this bill better in any way, I would be more than happy to work with you or any member of this committee or of the legislature for that matter to make this bill better so that we achieve what we hope to achieve here. I agree with you. The situation that we had in my district and in it was technically, I think, in Frisco, but in that the councilwoman from the colony brought up didn't include firearms at all. It was just a creepy dude in a lawn chair watching kids on a playground. And so, if we can shore this up, I'm happy to do a committee sub or do a floor amendment and accept that if we can make this bill better.
I'm a lawyer, so I'm short on original ideas, but maybe there is someone else here who has a proposal. My concern is that person who happens to be there and doesn't pose an obvious risk. Like if somebody shows up in body armor and a helmet with a rifle, yeah, that would make me pretty uncomfortable to drop my kid off as a parent, regardless of what their intentions were. I don't know the answer to this, and I leave it as an open question. Maybe some of the other committee members have an idea.
Representative Money.
Thank you, Mr. Chairman. Yeah, my idea was I think we just strike B2. And I'd be open to hear opposition from some of our more liberty-minded. I feel like I'm pretty liberty-minded, but
I used to think I was.
Yeah. I think that and this is what I was getting at with the lady from the Catholic bishops organization, is that I'm just not sure that as constituted, this bill is going to capture everything that we're concerned about, and I think it's going to create issues where there's a lot of judgment calls having to be made, not by whether or not we want that person here, but a judgment call made by whether or not we can prosecute based on that.
Yes.
And what we want to be able to do is say, if you're sitting in your lawn, this doesn't apply to you.
Mm-hmm.
So sorry, you're in your lawn, you're out there getting a tan, and you're looking across the street and enjoying, just hearing the sound of the kids playing and whatever. That might weird some people out, but you're on your own property. I don't know what we can do about that. But once you move into the sidewalk, the street, public park, wherever, and you show up with just a lawn chair and some sunscreen, we can say, why don't you move along? And if it's concerning enough for a school administrator to leave their office, go over there and ask the person to leave, maybe that should be enough. And if they don't leave, then they're open to prosecution.
I tend to agree with you that just having an. I'm sorry.
Wait just a second. Representative Bowers.
I yield to Representative Little if he has.
She's yielded to you.
Thank you, Chairman. I'm sorry for interrupting. I tend to agree with you. I think that we ought to be able to empower that administrator for whatever reason to ask that person to go, and that they ought to be able to contact law enforcement and get some type of action on that. So that may be a slightly shorter bill, but I'm concerned about the unconstitutional vagueness of 2B, and this may be a brighter line just for administrator to say, you got to go. The guy doesn't go. They call law enforcement. Law enforcement comes and makes them go. So, thought.
Well, let's do this. Let's encourage a lot of conversation and talk offline
Yes,
about
sir.
this bill, because I think it's definitely necessary. Representative Bowers.
Thank you, Mr. Chairman. Appreciate it. So I'm not sure, because I am not a lawyer, if this is what y'all are talking about, Representative Money and Representative Little. But Representative Patterson, does this bill define behaving in a manner that is inappropriate?
It does not.
Okay. So are you concerned, or is there concern that this language could be interpreted too broadly?
Well, here's what I'll say. I don't want perfect to be the enemy of good.
Mm-hmm.
I want something that law enforcement can utilize to move people along or to arrest them if they refuse to do so. And if this language is too broad, where we can accomplish that goal, then I'm more than happy to change that language to whatever this committee sees fit. If if this is the best that we can do this session, absent of better language, then I would rather get this bill moving and forward and through the process so that it doesn't stall out like it did last session. That's kind of where I'm at. I've done this where, we pass bills, we have seen unintended consequences, and we've come back and we've fixed them in future sessions. I'm happy to do that. I don't want to, by any stretch, have that imply that I'm willing to let someone's constitutional rights fly out the window just because, we can't get better language. But I will work with this committee to make sure that part gets buttoned up. And I would love to see this bill move forward in the process, and I'm more than happy, and I'm willing to state here on the record that if we need to do that as a floor amendment, even with some of y'all joint authoring this bill and working with us on that, I'm more than happy to do that.
Thank you. Thank you, Mr. Chairman, and thank you,
Yes, ma'am.
Representative Patterson.
Thank you, Chair Patterson. You right to close?
Yes, sir, I close.
Okay.
Thank you so much.
The bill will be left pending. The chair hears none. House Bill 355 is left, 353 is left pending. Now call Representative Hull, Chairman Hull, for 2073.
Thank
Would
you,
please,
Mr. Chair.
Would you please, the chair lays out House Bill 2073, recognizes Chairman Hull to present the bill. And you do have a committee substitute.
No, we don't. There's one that we are working on, but we do not have a, I'm sorry, yes, it's at the end of the week and a lot of bills. Yes, there is a sub, sorry.
Do
Yes.
offer a committee substitute for presentation.
Yes.
If you would, please explain your bill, please.
Yes. Thank you, Mr. Chair, committee members. Victims of family violence, sexual assault, or abuse, stalking or tracking are at an increased risk of repeated victimization due to the nature of the crime. During the time when an alleged offender is out on bond with conditions protecting the victim, or the victim has a protective order against them, violations of these orders are not always prosecuted because it can be viewed as a low-level offense despite the risk to the victim. This bill would enhance the offense of violating a bond or a protective order if while doing so the perpetrator was in possession of a deadly weapon, similar to how offenses are enhanced if committed with a deadly weapon. Currently, the violation of a protective order or condition of bond in a family violence or sexual assault case is a Class A misdemeanor. It is a state jail felony if the violation occurs in a case that is found to be a third-degree felony. This bill would add that it is also a state jail felony if, in violating certain conditions of the order, the perpetrator was in possession of a deadly weapon. A person who repeatedly violates an order 2 or more times can currently be charged with a third-degree felony. This would make repeated violations with a deadly weapon a second-degree felony. At this point, we should be seriously concerned with the safety of the victim if the offender is repeatedly violating orders with a court order, and I would hope that bond was revoked or that they're picked up on the new violation charge. I have worked with law enforcement, prosecutors, and most importantly, crime victims and victims advocates on this bill. I believe that in enhancing the seriousness of these offenses, we are also enhancing the safety of victims. Texas should lead the way in supporting survivors of these crimes and prioritizing their safety, and lead on prosecuting violators who have demonstrated through their disregard of those orders their willingness to threaten, intimidate, and use violent crimes against victims. I am happy to answer any questions. The substitute is identical to the introduced version, but a ledge council draft, so there are no differences. Again, happy to answer any questions.
Members, any questions for Chairman Hull? See none, reserve your right to close. Chair calls Molly Boyles. You shall be registered as Molly Boyles, Director of Public Policy. And are you on, for, or against the bill?
I'm for the bill.
Please state your name for us.
Yes. My name is Molly Boyles, I'm Director of Public Policy at the Texas Council on Family Violence, and I'm here in support of HB 2703.
Thank you.
Thank you, Chair. And thank you all for the time to speak today. I appreciate the time to be here. The Texas Council on Family Violence has the privilege of representing family violence programs all over the state, all in your districts as well. At TCFE, my dedicated colleagues produce a report every year called Honoring Texas Victims, and it shows research on family violence homicides in our state. And it brings forward the names of those who have lost their lives at the hands of someone who was supposed to love them. In doing so, we have years and years of research on where the nexus of risk lies for a victim of family violence. First, leaving an abusive partner is incredibly dangerous. This person knows everything about you, and in Texas, of the 200 primarily women who are murdered each year, the vast majority, over half, were in the process of leaving. At that time, many victims, as Representative Hull laid out, pursue either a protective order or when they are engaged with the criminal justice system, they are bolstered by the safety of a bond condition. This is critical because they have said, my life is at risk and the lives of my children may be at risk. Protective orders are a unique tool in that they are one of the only accessible and effective tools outside of a criminal trial. Bond conditions are critical when someone who has already indicated a risk has been released. Second, we also know that the vast majority, over 70% of all women who are murdered by their intimate partner will be shot and killed in our state. When you layer these risks together, it becomes clear that for survivors who are fleeing an abusive relationship and seeking a protective order or a bond condition, and the state happens to find that this person has a deadly weapon on them, we know the next step may be their homicide or that of their children. I also want to say I bring forward that this is research, but these are also the lives of people in our community that we love. In fact, looking at our data, in just the past 2 years, 6 Texans had a protective order of some kind and were shot and killed by their intimate partner. This measure might have prevented their homicide and those families who are now sitting without a loved one. With the imperfections present in available PO and bond data, there could be more. HB 2073 is a well-crafted bill by Representative Hull and her staff that simply puts an enhancement where it needs to be and is not now to protect survivors. I'm really impressed with Representative Hull for thinking about this, because there are many other instances, to your question earlier, Representative Moody, where you can have an enhancement for a deadly weapon, and somehow this is missing at one of the times we know the risk is the highest. So we urge favorable consideration, and I'm happy to answer questions.
Thank you. Members, have any questions? None. Thank you very much.
Thank y'all so much.
Chair calls Andy Kahan. Mr. Kahan, you show yourself registered as Andy Kahan, Crime Stoppers Houston and South.
Correct.
Okay. Are you on, for, or against the bill?
I am here supporting House Bill 2073 on behalf of Crime Stoppers of Houston and myself.
So that would be for?
Correct.
Thank you.
Yes.
Go ahead.
One of the things at Crime Stoppers that we started noticing, and we started doing weekly segments on local news called Breaking Bond. And in the last couple months, we have featured segments involving defendants who are out on bond, and one of their bond conditions was a protective order. And they violated that protective order time after time after time again, and then went on to further their career. I'll give you just a couple examples of recent stories that we've done on local news. 21-year-old Frank Norjay was sentenced to deferred adjudication after being convicted of assault with intent to impede breathing, which quite frankly is just a fancy word for trying to strangle somebody to death. 2 months on his probation, he was charged with assault and violating a protective order. Normally, if you're on probation and you get a bond, the bond gets increased. The judge actually gave him a $100 bond for violating a protective order, while he was on probation and allowed him to remain on probation pending the other charges as well. In addition, he also set $100 bonds for sexual assault and kidnapping as well. Again, that Frank Norjay went on to again further victimize the defendant as well. He ended up facing 7 felony charges, most of them all domestic violence related. But again, the point was he was out on probation, charged with violating protective order, violating his bond conditions, and still was allowed to remain on bond as well. That's just one of the examples right here. We had another individual who was out on bond. While out on bond, again, he violated a protective order. Once again, he was allowed to remain on bond. He was now charged with murder as well. I can go on and on and on about all these conditions as well. So I just feel that violating a protective order, particularly when you're out on bond, you are already basically stating, I am a threat to public safety. If you're not willing to abide by the protective order, why on earth are we allowing you to remain in the community? And we've seen hundreds and hundreds of cases like this that are documented. I can give you all that documented. And if you're willing to violate your protective order, we have to beef up the consequences and ramifications of that. And that's what Representative Hull's bill do, and we wholeheartedly support that bill as well. So let's do the right thing. Let's protect everybody. And very simply, honor your protective order, and you have no issues. When you violate your protective order, there's got to be some hell to pay for that. Thank you.
Thank you. Members, questions for Mr. Khan? Thank you, sir. Chair calls April Aguirre. You show yourself as registered as April Aguirre, representing self, on, for, or against the bill.
For the bill.
Thank you. Go ahead.
It is no secret that when women decide to leave their marriages, the period between leaving and actually being fully divorced is a very dangerous time. A lot of this time, they ask for protective orders, not only because there's the potential of violence happening, but because of past violent events. When an individual violates their order, they're sending a clear message to the judges and to the community that they do not care what type of implications are being imposed on them. Showing up to somebody's home after a judge told you not to only escalates. The majority of the murders that have happened within our community in Harris County are by individuals that already had a restraining order or a protective order. This basically tightens the belt for these individuals that refuse to follow the law and tries to give a little bit more protection for women and in some cases men in these situations when they're seeking protection from the court system. If they're caught violating this order, then it gives them a little bit more of the ability, more power to our prosecutors and our police officers to hold these people in custody or give them higher ramifications. I unfortunately, as crime escalates, more violence, we're seeing it in our own communities, and we have to address that. We have to evolve with criminal activity, and as we see more domestic violence, homicides, we need to respond by being able to try to prevent some of these, and I really do praise Lacey for coming forward with this bill and helping in that effort. I thank you.
If there's any question for Ms. Aguirre? See none. Thank you very much.
Thank you.
That's it. Is there anyone else who wishes to testify on or against House Bill 2073? If not, the chair recognizes Chair Hull to close on the bill.
Thank you, Chair Louderback. And unless members have any questions, I will close.
Representative Bowers.
Thank you, Chairman Lauderbeck, and thank you, Chair Hull, I just wanted to know about the portion of the bill where it allows victims to consent to DNA testing and comparison without filing a police report.
Oh, that's the other bill.
Is it? Do you have 1422?
We are on 20.
2073.
Yes.
We have not gotten to that.
Yes, yes.
I was ahead of myself. Well, I don't have any questions for myself.
Thank you, Representative Holt. If there's no objection, the bill will be left pending. Thank you. Oh, we need to withdraw the substitute. The bill will be left pending. The chair hears no objection. The bill will be left pending. So don't go far. You want to do 1422?
Yes, sir.
Okay. The chair lays out House Bill 1422, 1422, and recognizes Representative Hull to explain the bill. Chairman Hull.
Thank you. So this bill is one that I have spent a lot of time working on over the interim, speaking with survivors, prosecutors, law enforcement, and victims advocates about the ways we can work toward more successful prosecutions and have effective penalties in place for serious sexual offenders. First, this bill would create a third option for rape kit testing. Currently, if a sexual assault exam is performed and a kit is collected, that kit sits on a shelf and is never tested unless the survivor makes a report to law enforcement. These exams are long and invasive, and many survivors want to feel like they endured the exam for some sort of purpose, but aren't fully ready to make a report to law enforcement yet because it is such a huge and difficult decision. This bill creates a mechanism for a survivor to provide limited consent for the kit to be tested by DPS, and for DPS to notify a survivor if foreign DNA material is found. While the introduced bill discusses searching for profile matches through CODIS, I'm working on a substitute to limit this to a forensic DNA test done solely by DPS. Profiles will not be searched in a database unless the survivor subsequently makes a report to law enforcement. That, members, is the goal of this third option, to empower survivors to know if DNA material was found so that they can choose to make a report when maybe otherwise they wouldn't, out of fear of being believed or having the case move forward. I want to thank DPS for working with me on this. DPS has estimated that this will result in about 120 more tests run per year, which could mean 120 more cases reported and perpetrators brought to justice instead of kits sitting on shelves. I want to be clear that no survivor will be required to have their kit tested or required to make a law enforcement report or have their information shared with investigators without their consent. This is about empowering survivors to choose a third option for their kit. Now on to the penalties. This bill increases the penalty for voyeurism, which is now a Class C misdemeanor, and it would bring it to a Class A, and increases it further for repeat offenses and offenses against children, which is basically child pornography. This is to reflect what this crime really is, a gateway sex crime, and bring it in line with similar offenses like invasive visual recording. To further protect children, this bill expands the minimum 25-year sentence for aggravated sexual assault if committed against a child younger than 14. Currently, the super aggravated minimum sentence is only for children 6 and younger, or children aged 7 to 13 in the event of serious bodily injury. This would make the minimum for any child under 14. Finally, to assist in the prosecution of serial offenders, this bill does two things. First, it allows for sentence stacking of sexual assault and aggravated sexual assault cases, which is currently only allowable for offenses with a child victim. Sentence stacking is discretionary for the prosecution to request and the judge to grant, but currently that option isn't available even for the most heinous repeat offenders. Secondly, it establishes a new offense of continuous sexual abuse that mimics the existing offense of continuous sexual abuse of a child or disabled individual. This provides another tool for prosecutors to try a serial offender of adults by establishing an offense with a heightened punishment. I'm working on a substitute to address a drafting error that inadvertently created age gaps between the existing and new offenses, and to include this offense in existing parole laws. I look forward to continuing to work with stakeholders as we finish this draft of this bill, and want to thank them and y'all, the committee members, for the commitment to helping survivors and seeking justice. And I'm happy to answer any questions.
Members, are there any questions for Chairman Hull? Oh, yes, go ahead, Representative Bowers.
Thank you, Mr. Chairman, and thank you, Representative Hall. So now, your bill, this bill, allows victims to consent to DNA testing in comparison without filing a police report. So my question is, what problem is this provision trying to address?
So right now, it's not being done at all. They are just sitting on the shelves. And so if they can have it run, and then they would be notified if foreign DNA is found, then they have a choice if they would like to move forward with pursuing charges or not. It would be their choice. But right now, they have no way of.
So even with the Lavinia Masters, I guess that was the Lavinia Masters Act that was passed back in maybe 2017 by Representative Victoria Niave-Criado, the rape kits are still sitting on the shelves?
Yes, because they have not moved forward with a report.
Got it. That answers.
So this is kind of that in between, where they've done the kit, they have gone through the very invasive process of that exam.
But they haven't actually filed a police report.
Correct.
Okay, so there's that gap that
Right.
you're trying to close. And
Correct.
That makes sense to me. Thank you so much.
Yes.
Thank you for bringing this bill.
Thank you.
Thank you. Do you have any other questions? Think none.
Thanks.
If there are no further questions, we will proceed to testimony. The chair calls David Gonzalez, Texas Criminal Defense Lawyers Association. And so,
Yes.
you're registered as David Gonzalez,
Yes, sir, I am.
and you are registered on, for, or against the House?
Registered against.
Against the bill?
Yes, sir.
I think. Thank you. Go ahead.
Our testimony is limited to one provision about the jury unanimity.
Use the mic, please.
Yes, sir.
Thank you.
Regarding the provisions, when this body passed the continuous sexual abuse of a child prosecution, we gave a lot of latitude because children who are abused wouldn't know the exact date or those acts. And so the courts have said, we understand that you don't have to know those exact dates when the judge is drafting a jury charge for the jury to be unanimous. But the courts also have said in this footnote, and this is what we raised this concern on this bill, the court also said in the footnote, note that the current laundry list of what's called acts of sexual abuse include kidnapping and burglary, which may not fit within that. And so in the future, there may be an issue where this comes up again. There are not many things that criminal cases get reversed on appeal. The jury charge is one. And so in terms of drafting that charge, if the court then has a laundry list of 7 or 8 offenses, we just know that our organization will say this is the main part, where if there's anything to be tightened up, it's just what those provisions look like. Those are all our concerns.
Chairman.
Are there any questions for Mr. Gonzalez?
Chairman.
Representative Little.
Thank you. Mr. Gonzalez, you're talking about, it's on my page 9's provision. It's in C, 2103C, the proposed?
Yes, sir.
All right, let me make sure I understand this. First of all, I apologize that I'm not as up to snuff on where provisions like this appear in the penal code. Are there currently any other or similar provisions in the penal code where the jury is not required to agree unanimously on these specific acts?
It's word for word, except Chair Hull's bill is even more narrow because it requires 3 acts and not 2. but the continuous sexual abuse of a child language, she has mirrored that exact language.
So it's copy and paste over from there?
Yes, sir, with the exception that her bill increases it. So for super predators for 3 as compared to 2. So that's a difference that makes it more narrow.
But it's the current state of the law on continual sexual abuse of the child?
Yes, sir.
And if you were here testifying on that provision that exists, you'd say the same thing, wouldn't you?
I would say that we did when we testified against it. And
That's
I'll
what
tell you
okay.
that we lost. That the courts have said, no, the legislature had said, due to the nature of how children testify, if they want to give them the ability to not have to know an exact date or offense, that's why that can still be unanimous.
Well, and so the question I'll pose to you is, because this does not relate to acts against a child, do you think that the standard of or the burden of proof should be something different? Not burden of proof, that's not the right phrase, but do you think the unanimity requirement ought to be something different for adults as opposed to children?
Yes, because of all the findings this body has done that children don't know, semicolon, the footnote that says that some of those offenses like burglary and kidnapping aren't the same kind where you can be able to lump them together as those acts. And so I'm just looking at footnote 3 of this opinion from the Third Court of Appeals that just flags this for future reference. The Court of Criminal Appeals hasn't decided this yet. I'm just looking at intermediate courts when lawyers challenge that, sir.
In continuous sexual abuse of a child, it's 2 acts, and here it's 3?
It's 2 versus 3, yes, sir. So to some extent, this language is more narrow in that it's 3 and not 2. But in also situations, that's why I think there could be some different unity.
Let me ask a stupid question. I think, how do you establish the existence of 3 acts of sexual abuse if you can't say when they happened? Like, how does one do that? So, and it's an academic question, but I think it's important to what we're talking about here. Mr. Gonzalez says, members of the jury are not required to agree unanimously on which specific acts of sexual abuse were committed by the defendant or the exact date when those acts were committed. So if they don't agree unanimously on, I don't understand this. Can you explain it to me?
Yes, sir. Under current situations, if a child says, I don't know the dates, but I know my stepfather came in the room at night, and this happened over the course of weeks or months, the trial courts have said that's sufficient if the jury believes that more than 2 acts occurred over that time period. We don't have to know it was August, September, or what date. That's what the current law is.
Okay, and so I'm trying to understand or imagine a hypothetical in which the jury might not agree unanimously which acts there were. Let's say there were 5 acts, and these 6 jurors agree that these 3 happened, and these other 6 jurors agree that those 3 happened. You could get a unanimous jury verdict, or you could get a guilty verdict without the jurors agreeing on the same 3 acts?
That for continuous right now, that's the law. Yes, sir. And the difference that the footnote says is be careful because some kidnapping and burglary offenses have different elements that don't require. So let's say, for example, the 3 that we typically have: indecency with a child by exposure,
yep,
by contact, and sexual assault. Those can all be in the same transaction, unfortunately.
Yep.
That's different than maybe a burglary, a kidnapping, and so that's why I think the unanimity becomes really tricky in trial about what's extraneous, what's contextual evidence, what's the criminal episode. And right now, at least when we do that for continuous sexual abuse of children, it's different than when we start getting into, I think, adult situations, whereas, as you mentioned, it may be more defined as separate acts.
I'm struggling with it and why it's in there. That maybe some additional testimony would help.
Yes, sir.
Thank you.
Members, are there any other questions? Seeing none. Chair calls Brady Mills. Sir, you are registered as Brady Mills Division Chief for Texas Department of Public Safety Crime Lab.
Yes, sir.
Okay, and you're testifying on the bill.
That is correct, yes, sir.
Thank you, sir. Go ahead.
Yes, my name is Brady Mills. I'm the Chief of the Crime Laboratory Division at DPS, and I'm a resource witness, and I'd be happy to answer any questions.
Recognize Representative Little. No questions? Thank you.
Thank you, Mr.
Appreciate
Chairman.
it. Chair calls Andy Kahan. Mr. Kahan, you are registered as Andy Kahan, Crime Stoppers Houston and Self.
That is correct.
Testifying on, for, or against?
Testifying on. For.
Okay, we're testifying on? For the bill.
Correct.
Okay, thank you.
Getting too old. My name is Andy Kahn. I'm Director of Victim Services, Crime Stoppers of Houston, and I'm here testifying in support of House Bill 1422. One thing that we all know is how underreported sexual assaults and any crime involving any sexual of nature is. It is the most underreported crime that we have, not just in the state of Texas, but in the entire country as well. So any help that would encourage victims to report sexual assaults, which are obviously extremely difficult for any person to be undergoing, we think would be an advantage. And if it can help them report the crimes instead of saying, I don't want to be put through this, then we're all for it. The other issue that we really like in Representative Hull's bill is the stack sentencing, which right now we do have for anyone who's a child sexual assault victim. So the key thing in allowing stack sentences for sexual assault cases is discretion. And I love discretion. And the more discretion we can give prosecutors, the better off we're going to be. There is no downside to giving them an additional tool if they feel that this is something that they can use. So let's give them the additional tool to work with. And then finally, I certainly support giving the creation of a new offense of continuous sexual assault. We have it for children, we have it for disabled individuals, and again, discretion is the key word. So I like discretion, just like we like the bail reform bills, giving judges discretion. Now let's give that discretion to prosecutors, particularly in sexual assault cases. Thank you.
Members, any questions? Seeing none, thank you, sir.
See you soon.
Chair calls April Aguirre. We show you registered as April Aguirre, crime victim advocate, registering on, for, or against the bill.
For the bill.
Thank you. Go ahead.
So as times progresses, unfortunately, criminal acts are becoming more vile, and we need to give prosecutors and victims more tools. Not everybody is forthcoming about these situations, specifically being an adult. So this would allow victims to say, you know what, there is enough evidence there to prove what I know happened, and then go forward with criminal charges. A lot of the times, unfortunately, there's not always DNA present, right? And a victim might be reluctant to go forward, but if they ever do decide, the evidence is there. I think that, unfortunately, our culture has become so predator-driven, and that doesn't stop when a person turns 18 and they become an adult. So let's give prosecutors the tools, and as well as crime victims. Thank you.
Members, any questions?
Thank you.
Thank you very much. Is there anyone else who wishes to testify on or against House Bill 1422? Seeing none, the chair recognizes Chair Hull to close on the bill.
Thank you. And part of that, Representative Little, part of that section has to do with like a serial rapist. So it could be multiple victims. So the jury could say, kind of like what you said. The jury could say, yeah, we agree on these, we're unanimous on these, and some of the other ones could say, yeah, we're unanimous on these other ones. So they could still get the serial rapist on at least one. And so that is the goal of that. We are still working with stakeholders, and I know we've been working with a DA and other stakeholders who was not able to be here today, but we can continue conversations because we are working on a substitute for this.
Chairman.
Representative Little.
Thank you, Chairman. Representative Hall, thank you for addressing that. I'm just trying to understand how it works in real life. I think it would be good to hear from the district attorneys about why they feel they need this as part of the statute to gain a conviction. I am fortunate enough not to have ever tried a continuous sexual abuse of a child case. So I don't really know how the mechanics of that work when you go to a jury and what you're trying to get the jury to find. And so here, there's a series of offenses, any three of which could comprise the basis for a jury verdict. You've got a list of 8, and some of them are like burglary or trafficking. I'm wondering how that works out in real life, and whether we really even need C in the statute or whether it's helpful. But I'd like to hear from a DA on it.
Yeah, that, again, from working with, I'm not an attorney, I don't, but again, working with them, that was suggested in order to help prosecute these cases. But
Sure.
we can ask for some more information and get that to all the committee members.
Thanks so much.
Thank you, Representative
Thank y'all.
Chair Hall. If there's no objection, the bill will be left pending. The chair hears none. No one else wishes to testify on our behalf, so we're closed out. Okay. Oh, yeah, where's that paper? If there's no objection, bill's left pending. So the chair lays out House Bill 1160, for Chairman Hull to explain the bill.
Thank you, Chair Louderback. So after Hurricane Beryl and other recent natural disasters, media reports have widely reported the threats and harassment and assaults that utility workers faced in their vital work to restore power and critical services to Texas residents impacted by disasters. And I am in Houston, so that's why I'm talking about Hurricane Beryl. We saw it was a major problem. So while the offensive harassment committed against individuals are enhanced related to law enforcement duties, hospital personnel, and other individuals are enhanced, this enhancement does not apply to utility workers. Similarly, the offense of interference with public duties does not include utility workers who are conducting vital work for Texas residents. This bill would include a person the actor knows is an employee or agent of a utility while the person is performing a duty within the scope of that employment or agency. This would add that to the list for which the offense of assault can be enhanced from a Class A misdemeanor to a third-degree felony. This bill also amends the offense of interference with public duties to include interference with a utility worker in performing their duty within their scope of employment or agency. I know that frustrations can run high during times of emergency or disaster, but there is never a justification for the assaults and interference with linemen or other utility workers who we rely on to keep the lights on. I want to say we are working with stakeholders to make sure that all types of utility workers are included, so there might be a sub down the road if we need to change that language to make sure that they're all included. So unless anyone has any questions.
Members, are there any questions for Chairman Hall? I have one question, Chairman. Can you ask why broadband isn't included in this bill?
Yeah, so that's one of the, we're working to figure out what language we need to do in a possible sub to make sure that we cover all utility workers. We thought with how it was worded that everyone was covered, but we are hearing that maybe there are some people who are not. So again, that's why we're working on a sub to help clarify that.
Thank you. Are there any questions? Hearing none, thank you.
Thank you.
There are no further questions. The chair will call the first witness. Taylor Kilroy. And you are registered as Taylor Kilroy, Executive Director of the Texas Public Power Association.
Yes, sir.
On, for, or against the bill?
4.
For the bill. Thank you. Go ahead.
Thank you, Chairman Louderback, members and staff. My name is Taylor Kilroy, Executive Director of the Texas Public Power Association, and I'm testifying in full support of House Bill 1160 by Chair Hull. TPPA represents the 72 municipally owned electric utilities and other publicly owned electric systems that provide power to over 5 million Texans. In addition to our work here at the Capitol, at PEC, and at ERCOT, one of the things that we do as an association is coordinate mutual aid response, both in-state and across the country. You might have heard about hurricanes Helene and Milton that hit Florida and Georgia. During those storms, we were able to send out multiple crews to help our friends in other states recover. During Beryl, we were also able to send out crews from Texas Utilities to some small towns to help them recover from those storms as well, after the storm swept through Houston. Across the board, no matter where we were, our utility workers were treated with respect and appreciation. Unfortunately, as Chair Hull mentioned during her layout, that wasn't always the case in Houston. Stories of utility workers being robbed at gunpoint or threatened with violence quickly traveled across the industry, and I've heard from my counterparts in other states that next time a storm hits Texas, they may not be willing to send mutual aid. At the very least, it'll be a hard sell. To be frank, that is the thing that keeps me up at night, that if another major disaster hits Texas, we may not be able to procure sufficient mutual aid to help people get powered on again quickly. Mutual aid response already requires a big ask. We're asking folks to leave their homes, leave their families, leave their air conditioning, to travel across the country, often into the face of the storm if they're pre-positioned, directly into a disaster zone. The work is already dangerous enough without the potential for threats and injury from the people that are there to help. House Bill 1160 serves as a powerful message that the kind of behavior that we saw in limited portions during the Beryl restoration will not be tolerated, and we're fully supportive of the bill. TPPA appreciates the opportunity to provide this testimony. Thank you, and I'd be happy to answer any questions.
Thank you. Members, are there any questions for this witness? Thank you.
Thank you.
Our next witness is Ashley Myers. You're registered as Ashley Myers, Executive Director of the Texas Association of Water Companies, and you are testifying on, for, or against the bill?
Neutral on.
Neutral on the bill?
Yes, correct.
On the bill. All right, thank you. Go ahead.
Good afternoon, Chairman Louderback and committee members. My name is Ashley Myers. I'm the Executive Director of the Texas Association of Water Companies. I'm here to testify neutral on House Bill 1160. Under current Texas Penal Code Section 2201, assault is generally classified as a Class A misdemeanor, which carries penalties up to 1 year in jail and/or a fine of up to $4,000. However, these consequences fail to reflect and deter the seriousness of assaults against utility workers who perform critical services to Texas. I would like to share a few real examples of what some of our operators have endured. One operator was parked at a water plant completing paperwork when someone approached the truck with a knife, asking him to get out. As the operator opened the door and began stepping out, the attacker stabbed him in the face. The operator defended himself with a company tablet, wrestling with the attacker as he attempted to stab him in the body. The operator managed to escape and ran to the street where he flagged down a passerby for help. In another case, a contractor was pistol whipped and robbed at gunpoint. Another case, an operator arrived at a water plant to find a car parked at the gate with a man attempting to use bolt cutters to break the lock. When the operator confronted him from the truck, the intruder pulled out a gun. The operator quickly left to a neighboring facility and called the sheriff's office. The sheriff's office took over an hour and a half to respond. Although no shots were fired and the operator was unharmed, the situation could have escalated severely. Currently, the water and sewer industry is facing a serious workforce shortage. Addressing these types of issues would help in, obviously, incentivizing people to come work in our industry. The current penalties are not enough to deter these attacks, and utility workers should not have to fear for their safety or have their ability to do their jobs impaired. This bill is a necessary step to hold offenders accountable and prevent further violence, and we would appreciate if the author would consider including water and sewer retail public utilities to House Bill 1160. Thank you, and I'm happy to answer any questions.
Thank you. Members, are there any questions? Representative Money.
Thank you, Mr. Chairman. I wasn't aware that this was a problem, and so I'm not aware of all the problems in Texas, thank goodness. But and those stories that you provided were horrific. I would note that all of those would have been, I think, covered by different criminal statutes that already exist. This is not a simple assault, but stabbing someone in the face is, and brandishing a gun, hitting someone with a gun. Those are beyond just simple assaults. And so I wonder if you can explain, or if you know of under what circumstances there's just a physical altercation where there's not a deadly weapon or deadly force or anything like that used. What are those kinds of circumstances in your industry that are concerned?
Sure, absolutely. I can definitely speak to that. Similarly to the other utilities that are represented in this bill and probably in this room, water and wastewater operators do have to go onto private property, oftentimes to look at water meters, adjust infrastructure, and so that in and of itself can present opportunities for conflict, particularly if someone's really upset about their water bill. And we have had situations in that scenario where someone has to come onto the property to read a meter, someone's upset about their water bill, and that's where you see that conflict occurring. Of course, Chairwoman Hull mentioned in a disaster, when you're talking about having to address infrastructure needs in that moment, electricity is not the only infrastructure that is damaged in storms. We also have our own wastewater systems that are damaged, our pipes are damaged, and we do have to respond to those as well. I don't know of any stories in particular from our companies that our operators have been assaulted or threatened in those moments, but I know for a fact, and I have several other stories about our operators on private property being threatened, both with and without weapons.
Okay.
Representative Little.
Thank you, Chairman. Ms. Myers, you shared some stories about people who work for the water company who had been assaulted. Where did those happen?
So the individual who was stabbed in the face, that was in Houston. And from what I understand, the individual who did the stabbing was a juvenile and was sent to a rehab or a juvenile detention center. And at that point, no other action was taken. But I assume some kind of charges were levied onto that individual.
Well, I feel like we're kind of tap dancing around an issue here, and we've been doing it for weeks. Houston is systemically fouled up, and it's a part of an ideological approach to criminal justice that has now given birth to total chaos that happens to implicate water companies and happens to, from time to time, implicate utility providers. The question I have for you is, were these people assaulted because they worked for the water company or because they live in a criminal cesspool?
I do not have that answer, unfortunately.
Well, it's actually critical to our analysis here because I grew up in Houston, Texas. It is not the Houston, Texas of today.
Sure.
And I have many friends who still live there, and they're aware of what happened during Hurricane Beryl because there were certain electrical utility providers and linemen who were out doing work and were assaulted by people who were angry because the power was off. And so the philosophical question this subcommittee is dealing with is, are people being assaulted because they are employees of utility providers who need special protection? Or are they being assaulted because of an environment that was created by a political ideology and is not curable by changing the strength of an offense. Do you see the question that I'm posing?
I do, and if I could come to Houston's defense a little bit here, I will say one of our member companies up in the Dallas area has had instances as well with being threatened within their water system. So I do want to say it's not just solely within Houston, but I do understand your point that you're making.
Certainly. So I certainly don't mean to interpose that Dallas is without its ills. They certainly exist as well.
I feel like I'm digging a hole for everyone here.
The question the question of whether that I'm dealing with here, that we're dealing with as a subcommittee, is: are utility providers a special class of person entitled to a special class of protection? Law enforcement officers are, for very good reasons. In fact, let's talk about the law enforcement officer who was assaulted while he was in his police car sitting still in Houston, murdered on the spot because he was a police officer. And the question that I'm struggling with is, do we need to protect utility personnel as a special class of person, or are they simply among that class of humanity in Houston that is constantly at risk of violence because of someone's broken political ideology? What do you think?
I couldn't speak to the ideology aspect of it, but what I could speak to is that our operators provide a resource that is fundamental to life. And if we cannot provide that resource, if we are being inhibited by actors for whatever reason that may be, whether it's political or they're just plain crazy, for whatever reason that may be, if we're inhibited from doing that, people are suffering for that reason. And so I do think that there should be a special level of protection to make sure that those workers can complete their job, and that so those people in that area can receive the water that they need to brush their teeth, to drink, to
Let's
shower,
keep these
and so
remarks
forth.
to the bill.
I'm skeptical about that. Ms.
Chairman
Myers.
Little, please,
Yep,
to
please.
the bill.
I'm skeptical about that because I'm not sure that utility providers are per se subject to a higher risk and therefore a higher penalty, and I don't think it provides a deterrent to the same people who are causing chaos in other places. And so I pose to you, do you think that the people whose stories you told at the outset of your testimony were assaulted because they were working for a water company? Or are they assaulted because of the environment they were in?
Again, I couldn't speak to that.
Okay. Thank you, Chairman.
Any other questions for the witness? Thank you.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 1160? If not, Chair recognizes Chair Hull to close on the bill.
Thank you. A couple things in closing. What we saw during Hurricane Beryl in Houston was, and I will say things in Houston are a little bit better with our new mayor, but I would say it's more of the train wreck that is Harris County, not really so much Houston. And so I'm standing up for Houston a little bit there, but I would definitely say it's more the dumpster fire that is Harris County. But the utility workers were definitely targeted because they were utility workers. And we even had utility workers from other parts of the state, out of state, coming in to help that said, we don't want to come back because they were targeted specifically for being utility workers. There were threats on them. They were harassed, assaulted specifically for being utility workers. And I do want to say that we did receive language for the water, the wastewater utility workers to include them in there, and I am happy to do that. The broadband people, they had reached out. As far as I know, they have not gotten us language. And so, but again, we're happy to include anyone that needs to be included. It was very clear that these workers were targeted because they were utility workers. Even someone mad about their water bill and blocking their water meter, or mad that someone wasn't working fast enough to turn the power back on. It's like, well, assaulting the utility worker or the lineman isn't going to make your power get turned on any faster. So I just want to make that clear. I can't speak for everywhere else. I just know what happened in Houston and Harris County. So they were definitely targeted because they were utility workers. Unless anyone has any other questions, I will close.
Seeing none, Chair, thank you, Chair Hull. If there's no objection, the bill will be left pending. The Chair hears none, and House Bill 1160 is left pending. Thank you. The Chair lays out, we're going to do 14. Chair lays out House Bill 1443 and recognizes Representative Schatzline to explain the bill.
Thank you, Chairman. Thank you, members. Some might call this the Justice League of New Criminal Offenses. I'm not sure who's calling it that, but I certainly am. And I'm honored to lay out a very, very important bill. And to get serious, I am shocked that I even have to lay out a bill of this nature. But I think that it's incredibly important to bring attention to HB 1443, which creates a criminal offense for the promotion of or possession of childlike sex dolls, which is defined as an anatomically correct doll, mannequin, or robot resembling a child that is intended for sexual use. These objects are deeply disturbing and have no place in our communities. They resemble children and are designed for sexual stimulation or gratification. HB 1443 aims to close a legal gap and ensure these materials are treated with the seriousness that they warrant. So let's talk about what this bill does. The bill would create penalties for the possession of and the promotion of childlike sex dolls. If an individual is found to possess one of these dolls, they will be charged with a state jail felony. If someone possesses 2 or more of these dolls, the law will presume that they have intent to promote them, and they could be charged with a 3rd-degree felony. And if someone possesses 2 or more of these dolls, the law will presume finally, if an individual is caught promoting these dolls in any way, they will be charged with a 2nd-degree felony. Members, I was not shocked to find out that the studies show that the possession of childlike sex dolls is a clear warning sign that an individual may be prone to commit sexual acts with a child in the future. And in many ways, we've seen in studies that these dolls, and forgive me for the graphic nature, are used as practice for sex offenders to build up the nerve to commit the horrific acts that they're doing. We must end the sexualization of children and the normalization of pedophilia in the state of Texas, and I think this is a good step in the right direction. We do have witnesses, and I'm happy to answer any questions, and I would like to reserve my right to close.
Thank you, Representative Schatzline. Before we do that, I understand there's a committee substitute. The chair lays out and offers a committee substitute. If you could just explain the substitute
Yes.
briefly, Representative Schatzline, that would be helpful.
Absolutely. So we made a few changes. One of the things that we wanted to do is, and really what distinguishes this bill, maybe compared to some of the bills that y'all have heard or have been filed, is that many bills are trying to create a penalty for the distribution of childlike sex dolls. We want to make sure that not only is it illegal to distribute them or to promote them, but it's also illegal to possess them. I think it's a clear warning sign when we find that someone has a hold of one of these really just diabolical and horrific objects, and it needs to be addressed head on. And so one of the things that we changed is, first and foremost, the possession with intent to promote is no longer the charge of a Class A misdemeanor, because we truly believe that this deserves jail time. We believe that this is participation in the grooming of child predators, and we need to hit it head on. It also changed from possession was not an offense to now it's a state jail felony. And then The presumption of intent to promote, we had in the former bill, 6 or more dolls had to be owned. We just think that's a bit excessive and unnecessary. I don't know who came up with that number, but that was the study that was done in the past for previous sessions. So we just changed that to 2 or more dolls. So that's essentially what this committee sub changed to.
Thank you, Representative Schatzline. Members, are there any questions for Representative Schatzline? All right, if there are no further questions or no other questions, the chair will first call our first witness. The chair calls Caden Lopez with the Texas Family Project. Thank you for being here today, Mr. Lopez. We show you registered as Caden Lopez on behalf of the Texas Family Project and yourself, and you are testifying for the bill. Is that correct?
Correct.
All right, please proceed.
Good afternoon, members. My name is Caden Lopez, and I'm the Executive Director of Texas Family Project, and I'm here in support of House Bill 1443. This bill represents a necessary step towards safeguarding our children from exploitation and upholding the values that define our communities. Childlike sex dolls are not mere curiosities. They are a disturbing manifestation of societal decay and pose a serious threat to the well-being of our children. These dolls are obscene, anatomically correct, and designed for sexual stimulation. Their existence not only objectifies children, but also contributes to a culture that normalizes child exploitation. Texas should take a strong stance against these products, ensuring we send a clear message that the sexualization of children is intolerable. House Bill 1443 takes this decisive stance by classifying the promotion of childlike sex dolls as a felony. These message At Texas Family Project, we are dedicated to creating a society where families are protected and children can thrive. This bill aligns directly with our mission to shield children from exploitation and maintain the innocence of Texas kids. And we're thankful to Representative Schatzline for his leadership on it. I urge each of you to support this bill. It is about setting a standard for our society that prioritizes the safety and well-being of our children. We must unite to ensure that Texas remains a beacon of hope and protection for families, standing firm against any forces that seek to undermine our children's innocence. Thank you for your time.
Thank you, sir. Members, are there any questions for this witness? Thank you, sir.
Thank you.
Yep. To this one, AJ. Thank you, sir.
Deborah Simmons is up. Chair now calls Deborah Simmons. We show you registered as Deborah Simmons, representing self.
Yes.
Are you testifying on, for, or against?
For.
Testifying for the bill. 1443. Thank you.
Yes,
Go ahead.
please. My name is Deborah Simmons, and I am testifying for HB 1443. Thank you for considering this bill. Utah's statute adopted in 2023 defines childlike sex doll as an anatomically correct doll, mannequin, or robot with the features of or with features that resemble those of a minor, and is intended for use in sexual acts. Tennessee's statute, adopted in 2019, includes a language intended for sexual stimulation or gratification. Florida law, adopted in 2019, states a person may not knowingly sell, lend, give away, distribute, transmit, show, or transmute. Offer to sell, lend, give away, distribute, transmit, show, or transmute, have in his or her possession, custody, or control with the intent to sell, lend, give away, distribute, transmit, show, or transmute, or advertise in any manner an obscene childlike sex doll. One academic journal states that childlike sex dolls specifically mimic the shape and size of real children's bodies. They differ from so-called reborn dolls in that they have body openings that can be used for sexually penetrative acts. The journal distinguishes sex robots from sex dolls as additionally equipped with artificial intelligence or technical extras. For example, they can turn their heads or simply speak simple sentences. then further explains that dolls or robots differ from other sex toys in their complete replica of a human body, although it is also possible to only buy a part of a body like a torso. However, the early inflatable versions have considerably evolved, and today's dolls are tailored to customer preferences, raising debates about their classification as mere sex toys or as non-human partners. In the state of Texas, possession of a childlike sex doll is not documented nor recorded as a statistic because the possession of such a doll is not a crime in Texas. Texas should prohibit the possession, sale, and distribution of childlike sex dolls that have the features of or have features that resemble those of a minor, regardless of whether the doll is recognizable as an actual child or imagery of a child. And we need to consider providing civil liability for use of an actual child's image. Thank you.
Thank you. Members, are there any questions for the witness? Thank you. Is there anyone else who wishes to testify on, for, or against House Bill 1443? If not, the chair recognizes Representative Schatzline to close on the bill.
Thank you, Chair and members. Once again, I really believe that we in Texas have the opportunity to lead on this issue and become a state that sends a clear message that we are going to end the sexualization of children. I think this is a great step in the right direction. I'm committed to working with each of you to get this across the finish line, and I ask for your favorable consideration on this bill. And with that, I close.
Thank you. The committee substitute amendment is withdrawn. If there's no objection, the bill will be left pending.
Representative Louderback, may I make a motion?
Go ahead.
I move that we favorably refer House Bill 1443, the complete committee on criminal jurisprudence, so that it may continue moving forward.
Call the roll. Let's see. The question occurs on the adoption of the motion. Clerk will call the roll.
Chair Louderback,
Yay.
Representative Moody, Representative Bowers, Representative Little,
Yay. Aye.
Representative Money.
I want a clarification. Are we voting on the committee substitute? Because
No, so.
you're the committee substitute. I just want to make sure procedurally I understand where we are and what we're voting on. I'm in favor of it, but
So technically, we're just recommending it to go to the full committee, and then the committee will decide whether or not to do a sub.
okay, we can't decide that here. Or,
I don't think so, but tell you what, can you stand at ease for, can we stand at ease for a few minutes so I can make a call to make sure? This is all new with this permanent subcommittee.
okay, all right. I don't mean to overly complicate. I just want to make sure that we're all clear on what we're voting on.
Please stand by for a quick call.
He had a sub. He did have a sub. Yeah. But then
Was that sub?
You said we would draw the sub and move whatever, and then you made a motion, and I wasn't sure.
Yeah, we did it right.
You wanna move the sub, move forward. That's what I want.
You have to withdraw it to do that.
You have to withdraw it to vote on it?
Yeah.
What does that mean? would draw something. It's,
Yeah.
yeah. Oh.
So what were we voting on? Were we voting on the committee side or were we voting on?
Yeah.
Yeah. We have another opportunity.
Good idea.
Did you get you something to eat? Did you get me something to eat? Did you get something to eat?
Well, you were doing it right to make sure that, on the second, because I need to, just to make sure it's. Right, so good job. They could have. $6.
What was your question?
All right, the meeting will come to order.
Mr. Chairman, I withdraw my previous motion.
Members, any objection to withdrawal of a motion? Hearing none, the motion withdrawn. Members, the following motion in writing by Representative Little. I move that the subcommittee chair inform the committee chair that the subcommittee has completed its deliberations and recommends that Bill HB 1443 be scheduled for consideration by the full committee. The question occurs on the adoption of the motion. Clerk will call the roll.
Chair Lauterbach,
A.
Representative Moody, Representative Bowers, Representative Little,
Aye.
Representative Money.
Aye.
You got three? Yep. There being 3 ayes, 0 nays,
Two absent.
2 absences, and the motion prevails.
Now you go on to Cook's bill.
Do what?
Right, you can-
Okay. All right. The chair lays out. Let's see. House Bill 1902. It recognizes Chairman Cook to explain the bill.
Thank you, Chairman Lauterbach, and I do have a committee substitute.
We do, let's see. Do what?
The chair lays out the committee substitute.
Okay, please lay out your substitute.
You need to say the chair lays out committee substitute.
The substitute has been laid out, Chairman.
Chair lays out committee substitute.
Thank you. Members, the Texas Department of Banking defines jugging as targeting a person who has just withdrawn cash from a bank or ATM, following them to a new location and robbing them. Jugging is not a crime of opportunity like burglary of a vehicle or traditional robbery, but rather an organized crime with sophisticated surveillance tactics and plentiful resources. Jugging crimes usually follow a similar fact pattern. Criminals will lie in wait outside banks or retail establishments for hours on and without exiting their vehicles. They may use rented vehicles or vehicles with fake tags or no tags at all. A spotter vehicle will identify potential victims who they think are carrying a large amount of cash, usually by spotting bank envelopes. A follow-off vehicle will be staged in the parking lot ready to follow the victim. And a Trojan vehicle who remains in communication with the follow-off vehicle and targets the victim at a secondary location. Members, this crime is happening in all of our communities. Chairman Lauterbach, in 2019, the Victoria Police Department arrested 3 criminals who stole over $10,000 in a bank envelope from a woman in a jugging incident. There's been incidents at Buc-ee's in Royce City and in Representative Money's district. There's examples all throughout all of our districts, and this is a crime that is becoming more and more common and needs to have its own offense, and that's what we're here for today. The committee substitute to HB 1902 creates the criminal offense of jugging and makes it a state jail felony. Jugging is defined in the bill as with intent to commit theft of another person's money. A person, quote, knowingly travels from a commercial business or financial institution on the same path or route as another person without substantially deviating from their path or route and possesses 2 or more criminal instruments. The addition of commercial business in the substitute will expand the offense of jugging to include retail stores, shopping malls, and high-end storefronts like the Galleria in Houston, having been spikes of jugging incidents in that particular area. The committee substitute enhances jugging to a 3rd-degree felony if the criminal commits burglary of a vehicle and a 1st-degree felony if the criminal commits robbery. We remove the filed bill's enhancement for aggravated robbery as it is already a 1st-degree felony under existing law. Members, I appreciate your consideration of this critical public safety bill, and I'm available for any questions. Would like an opportunity to close when appropriate, Mr. Chairman.
Members, are there any questions for Chairman Cook?
Just real briefly.
Quit.
Thank you, Chairman Lauterbach. Representative Cook,
Yes,
I
sir.
was studying this bill pretty closely last night, and I got hung up on one thing. So in your, first of all, let me just acknowledge, this is a thing. It deserves a statute, and I'm glad that you're bringing it. under A2, one of the elements of the offense is being in possession of 2 or more criminal instruments. And not being a criminal lawyer, I tried to figure out what that was, and I went to section 16.01 of the penal code, and I found the definition of it unsatisfying. So I went to it, and it says criminal instrument means anything the possession, manufacture, or sale of which is not otherwise an offense that is specially designed, made, or adapted for use in the commission of an offense. And I couldn't figure out what it was supposed to be. What are the 2 or more things someone who engages in jugging is supposed to have?
We do have other witnesses that will testify, but what I've been made aware of is just different elements that criminals would use, whether that's whether it's an instrument like a physical weapon that's utilized, or any type of object that's used to help plan. Whether it could be a phone, it could be. It's very. I agree with you. The definition could be better stated, and I actually think you'll hear some testimony on that specific issue this afternoon.
Thank you, Representative.
You bet.
Any other questions? Thank you, sir.
I'd like an opportunity to close when appropriate. Thank you, Chairman.
Thanks. If there are no further questions, the chair will call the first witness. Jennifer Szymanski.
Thank you,
And you
Chair,
are-
members of the committee. I'm Jennifer Szymanski, Deputy Executive Director for CLEAT, or the Combined Law Enforcement Associations of Texas, testifying for the bill.
Thank you.
We represent 28,000 law enforcement officers across the state, and many of those are from large cities across the state, as well as suburbs of those cities. This was brought to us over the last several years. Many members have asked us to work on this bill, so we appreciate the representative for filing this important piece of legislation. To go with the trend, Representative Little, with Houston, I think you'll hear a lot of this is originating out of Houston. I believe there was a bill in 2017 that tried to address this that did not make it to the finish line, but since then, this crime has obviously perpetuated into something that is a critical issue across the entire state, and you'll hear a lot of testimony about that. Today, we've tried to work with stakeholders on a couple other bills filed in this realm that are out there. Thus, the sub that was introduced, we're trying to get to the best language possible to pass this bill for our members and our, again, in these large cities, these detectives who are trying to work these cases but have been faced with many hurdles when it comes to the prosecution. So we're trying to work with the DAs as well to get to a resolution. I think the majority of the questions will be better suited toward the witnesses that are going to follow me, that are working these cases every day. But happy to try to answer if anyone does have one.
Are there any questions for this witness?
Just real briefly. Ms. Szymanski, do you know what the criminal instrument is supposed to be?
I think there is a witness behind me that he has described to me what those typically are. We're open to if the DAs feel there's a better definition out there, but I think there are some common instruments that are used in the commission of this offense, and they can describe exactly what those are for you.
Thank you.
Yes, sir.
Are there any other questions? Thank you.
Thank you.
John Nelson. Chair calls John Nelson.
Chairman Letterback. Representatives, thank you.
John Nelson, representing Austin Police Department.
Yes, I'm a detective, a robbery detective with the Austin Police Department. I am here to testify for the bill today.
For the bill, thank you. And you are for yourself, correct?
For my personal professional role as a detective in these crimes, yes, sir.
Yes, thank you.
Thank you for your time, and thank you, Representative Cook, for proposing this bill. I'm here to testify on behalf of all the peace officers with the Austin Police Department, with the 28,000 peace officers in the state of Texas, but also with any police officer and investigator in the United States, because this crime does spread beyond the Texas borders, but obviously I deal with the crimes that occur here in Austin. So, as set forth in Bill 1902, we would establish a specific title code for jugging. Obviously, we have theft, we have burglary, we have robbery. So part of the testimony today is to explain why we're trying to fill that gap, which came up earlier in other testimony. The jugging MO, the modus operandi, is specifically designed to avoid higher level charges. It is premeditated, it is sophisticated, it is well planned, and it is organized. These obviously happen, these jugging crimes obviously happen all the time, day in and day out in Houston. But obviously a lot of other agencies are having to deal with this. And that is another aspect of this crime, is that suspects are traveling long distances, crossing multiple jurisdictions, which hampers investigation and coordination when trying to identify suspect vehicles, suspect actors, and charge them as a whole. Having a specific judging title code or offense will establish an arrestable offense for the observed preparatory criminal activity. That is going to be the state jail felony level. What we will see a lot of in our proactive operations against this crime type is, and what we're seeing now too, is a lot of bank representatives are calling in these suspicious vehicles ahead of time that they observe in their parking lot. So if the suspects kind of figure out that police are onto them or that bank personnel are onto them and they leave, but a suspicious call, maybe a patrol officer stops that vehicle, what it is going to turn out to be 99% of the time is a rental vehicle out of Houston or the Harris County or broader Houston metro area. It is a rental vehicle, but it has been altered. It has been adapted. It is typically tinted, which is not standard for the rental company. The suspects have applied that themselves. So I would look at the rental vehicle itself as a criminal instrument. What you will also have, the ideal crime is a burglary, because that avoids direct confrontation with the victim. They avoid any risk of having a robbery charge. They follow the victim to a secondary location. A burglary of a vehicle takes maybe 10, 15 seconds. You'll hear additional testimony about specific cases, and I can go into some of ours here. But a burglary is a misdemeanor. If they get caught, they can sweat that. It's not a felony, it's not a robbery. If they get stopped ahead of time before they actually commit a burglary or a robbery, they're just stopped by a patrol officer on the road, they can explain that this is a rental vehicle. It's not theirs. The rental vehicle is going to be clean. They travel without weapons typically, because that would also enhance charges. They travel without drugs. They keep their car clean. They're often very confident and willing to provide consent for a search because they believe that police officers are only looking for guns, drugs, things like that. They can typically explain away their positioning in the vehicle, which is commonly a getaway driver who stays in the car, and a jump out, or the Trojan vehicle that was described is the vehicle that's actually committing the crime. It's a backseat passenger. They will frequently wear work vests. They'll say they're work friends, or the driver will explain that he's an Uber driver and that this is just a passenger that he's driving, or that they're just hanging out in Austin, in my experience, to go to 6th Street or something like that. They have some other reason for being here. They can't explain why they drove into Austin to go to 6th Street during business hours. In follow-on investigations of suspects' cell phones, we will see their travel patterns are extensive within Texas, but also frequently make broad loops across the United States. I've seen suspects that have ongoing notes in their phone applications for every bank along their route across 8, 9, 10 states. Which banks are open on Saturday, what bank has good position where they can watch from a neighboring parking lot without having to be positioned in the bank parking lot. So it is highly organized, very sophisticated, and the only tool you really need to bring along with you is typically a window brake, which is a search and rescue tool, or a screwdriver. Again, commonly you're not going to carry a weapon because you want to avoid any kind of weapons-related charges or minimum sentencing. But a screwdriver can easily be used, and a window brake, I would say, is a search and rescue tool that has been adapted to their criminal activity, which would just be burglary. So the state jail felony level charge would offer officers and detectives an arrestable offense for that preparatory crime of following someone off from a bank to a secondary location. And then it would escalate from there to the burglary charge and then a robbery committed, or a jugging committed with a robbery.
Thank you, sir. Members, are there any questions for this witness? Representative Money.
Thank you. I agree. This is a bill that needs, or an offense that needs to be added. We've had several of these over the past few years in my small town. And I just want to make sure that you believe that this bill as drafted would capture everyone that's doing this and that there's not enough loopholes to get out of it. So we've heard that it's sometimes an organized crime where you have kind of a spotter and I think a Trojan and a follower, and so you've got multiple different people doing different things. Are you going to be able to prosecute them all as this is drafted? Let's say you have someone in a grocery store next door, is watching, you say, I just watched somebody come out with an envelope, and then, and they just turn right on First Street, and they're following them out that way. And so then somebody follows them for a while, and then when they get there, someone else comes in, knocks the window out, grabs the envelope and goes. So would you be able to prosecute any or all of these people with this statute as written?
Thank you, Representative. As a detective, we see these cases day in and day out. The minimum resources you need is just one car with two people, commonly. So that would be the primary target car who is following the vehicle and traveling in the same path as the victim. I think that captures that. Because like you were indicating, we do frequently, when we're out conducting surveillance, looking for these in a proactive manner, we are also on the lookout for counter surveillance because they do commonly use multiple vehicles. I would say it's all organized. Those are your more organized and more professional criminals. But the bare minimum and the primary target is that single vehicle that's following a victim off with one passenger and one driver. That is going to day in and day out. I got called multiple times about it happening yesterday, and I've been texted multiple times about it happening right now in Austin just while I've been here. A more advanced option is the multiple vehicle methodology of jugging, and that's what we're constantly looking out for. If we think we see one vehicle, we're going to be looking for multiple.
So I guess, and I'm not a criminal lawyer, and I'm not a criminal bill drafter, but if I had been approaching this problem, my thought would have been, it's theft that involves some sort of pursuit and knowledge that there's something in particular of value that I'm going after. And so to me, the fact that this, that the traveling from a commercial business or financial institution on the same path or route as another person without substantially deviating from that path or route. Once again, I'm not a bill drafter, but I could follow someone all the way and then let someone else know. I just keep on driving, let someone else know who meets us there, or who meets that person there, finds their car and opens it, and now that person has only committed a burglary of a vehicle because they have not been part of the following. But that person does know that they have been followed, they've been tracked. They've come straight from the bank with an envelope, and so I really want to. I want to do what this bill seeks to do, and I want to make sure this accomplishes that purpose. And do you think that it does as it's written, or is there a way that it could be addressed differently to make sure we're capturing the offense?
Yes, sir. I do. I believe that it does, and I believe that the vast majority of cases, you're going to catch the primary suspects The follow-off is the person following the victim to that secondary location is commonly the one that executes the final burglary.
Okay.
And their expectation is if we get caught and it's just a burglary, we can sweat that. I would say we also commonly charge engaging. So if you do have those additional vehicles or you only get one of those vehicles stopped and it requires additional investigation to identify who was in those other vehicles that got away, which I mean frequently happens just because we may only be able to get to one of the suspect vehicles. The follow-on investigation into their cell phones, into their cell connections, locations, that would identify the additional, and then we would commonly charge engaging for the whole group.
Okay.
But the base level charge, I think, is the key here. Is that that preparatory offense of following and possessing the criminal instruments? Because if we stop them before they've actually committed that burglary, we would still have an arrestable offense because we would be able to prove up that they had followed the victims from that bank or commercial building to whatever secondary location they were stopped at or stopped the victim at.
And to Mr. Little's kind of point earlier, how important is it that they have two or more criminal instruments? Is that something that is needed in order to get from theft to jugging, or is that something that is just something else that you're going to have to establish by evidence and the prosecutor's going to have to prove? If we know they tracked them down, but they didn't use any criminal instruments, it's still jugging.
Yes, sir. It's still jugging. They could not be using a criminal instrument. That's why I believe and look at the rental vehicle, because 99% of the time it is a rental vehicle. They've applied their own tinted windows, and they will remove that when they return it. And they are using a third party to rent that vehicle. It's just another way that they kind of obfuscate their connection to the crime. So in my understanding, that first criminal instrument is going to be the rental vehicle that they've adapted to the crime. I think the vast majority of cases you will find a screwdriver, a window punch, or some other item used in burglary, which would be your second. There are other options that were proposed and looked at, gang involvement, past cases. This, I think, is a well adapted to the crime.
Okay. Okay, thanks.
Members, any other questions for this witness? Thank you, sir.
Thank you.
Victor Baylor. Chair calls Victor Baylor. Your register is Victor Baylor, El Paso Municipal Police Officers Association.
Yes, sir. My name is Sergeant Victor Vela. I am the first vice president for the El Paso Municipal Police Officers Association. And I also run...
On for or against the bill?
For.
Thank you.
So in El Paso, I actually run our tactical unit, which we handle burglaries, robberies, any kind of crime trends. Not to beat a dead horse, I just want to go over some numbers that we had. Since 2018, we had one jugging case in El Paso. 2021, 1. 2022, 2. 2023, we had 5. 2024, we had 23. And year to date, this year, we already have 8. So as we can see this, as you guys are all understanding, that this is continuing to get worse and worse. We do have a main nexus in Houston who is teaching and training people from El Paso. One of the biggest issues that we run into is, yes, they're using rental vehicles, but they're also going to local apartment complexes or hotels, and they're stealing tags that are similar make and models. So that could be constituted as one of the criminal instruments. They're breaking the window every time. So that whatever they're breaking the window with could be the secondary criminal instrument. So there would be the 2. I don't think necessarily we have to have 2, but primarily there's always going to be at least the 1, which is whatever they're breaking the window with. we continue to see an increase of, as soon as they hit and we actually get a license plate, that plate within an hour and a half is hitting in Arizona and California. It's already out of state. And then we get video surveillance after the fact. And as they're coming back through El Paso from Arizona, California, they swap out vehicles, these rental vehicles in California and Arizona, and then they reoffend in El Paso on their way back to Houston. So we continue to see this upward trend of, organized criminal activity, and I believe that the statute as written will help fill the gap to help provide justice, for these residents of Texas.
Thank you. Members, are there any questions of this witness? Thank you, sir.
Thank you.
Chair calls Kayla Allen. Ms. Allen, you're registered as Kayla Allen, First Assistant, Galveston County District Attorney's Office.
Correct, yes.
On, for, or against the bill?
Yes, for the bill.
For the
So-
bill. Thank you.
Good afternoon, Chairman and committee members. My name is Kayla Allen, and I'm here on behalf of the Galveston County District Attorney's Office, speaking in support of House Bill 1902. I've spent 20 years prosecuting cases in Galveston County, and jugging has been an ongoing and increasing issue in my area of the state. In fact, the issue has gotten so bad that we have been working with our local law enforcement partners, along with State Representative Bonin and Senator Middleton, and they have both filed legislation this session to address the issue in a way that would allow prosecutors to obtain convictions against those attempting to commit crimes. We have worked with the legislature along with law enforcement stakeholders to identify the legislative changes needed to help curb this crime.
Excuse me, you'll have to stay on this bill.
Yes,
Thank
yes,
you.
sir. When a criminal searches for what they consider to be an easy target, then stalk the target as though they are being hunted, and our hardworking law enforcement officers are able to intercept them before they're able to victimize members of the society, we need legislation that allows us to charge them for the crime that they are actually preparing to commit. House Bill 1902 is a step in the right direction. I'm committed to working with the legislature to get the best piece of legislation possible passed into law. With that being said, I think I can answer probably both of y'all's questions. To answer your question on what constitutes a criminal instrument, I do think there is an issue, I agree with you, using the definition of 16.01 for a criminal instrument, because the way that is worded is it says that it needs to be specifically designed, made, or adapted for the use in the commission of the offense. Here is what our courts have shown. Getting convictions on these cases hasn't necessarily been difficult. Upholding them in the Court of Appeals is what's difficult, because what the court has ruled is, and I'll give you an example, a case of a man who is standing at a pawn shop at 2 o'clock in the morning, looking in the window of a pawn shop when it is closed, with a Slim Jim in his sock, a military-grade flashlight, along with a cotter pin and other burglary tools. They went to trial on it. They got a conviction. The Court of Appeals overturned it because they said not one of those items had been adapted or made or designed to commit the offense. And so using that definition will not allow us to prosecute the case. When we say 2 or more, the reason that I think that's important is because if you pull somebody over and they have a screwdriver, as a prosecutor, I think it is going to be very difficult for me to convince 12 jurors that someone following someone that has a screwdriver, that's enough. So to answer your question on criminal instruments, what we are seeing in Galveston County is when they get pulled over, they have zip ties, duct tape. They do have screwdrivers. They do have things that the cars are rented. They have out-of-state license plates. And he's correct. A lot of times they have dark tint. Here, as a prosecutor, the issue is, how do I prove that they were the person that put the dark tint on the vehicle? I have called multiple rental vehicle places and asked them, when you receive that vehicle, did it have the dark tint on it? Because my thought is, if I can get somebody to come and testify and say, no, when I rented it to that person, it did not have the dark tint, they had to be the one to put it on, then that would help with the definition of they had adapted it specifically for that crime. But these cars come from out of state, and there's dark tint on them that people put on them, from what I'm being told, and when they come and move from state to state, it might not be legal here, but they don't take it off, or at least that's what they're telling me. So I'm not going to be able to call somebody from one of those rental places to say, no, when I rented it to that person, it did not have that tint on it. So I do think this is a step in the right direction. I do think that it is a huge problem, which I think is why a lot of reps have kind of, I think Dr. Bonin did either co-author or jump in on this bill, because I think it is extremely important for us to prosecute these cases. I think, to answer your question, yes, there's ways that we can charge engaging for the people that might be the spotters. You have to be able to prove, though, that they were part of that. Also, for engaging, you have to have 3 or more persons, and a lot of time you have 2. But you can charge people as a party. I think my answer your question is, if we can prove that it was someone in a different vehicle that was the spotter, and we can make that connection, you can charge them under a party, and that's with any crime. So,
Members, are any questions for this witness? Yes. Representative Money?
Thank you, Chairman.
I'm sorry.
Yeah. So, Ms. Allen, I'm trying to understand what we do with this criminal instruments piece, because I share the same concern that you do. I don't know that tinted windows is going to get you there. So is the offense intended to capture the situation where you got these people before they committed the act, like you pulled them over? Or because if they've committed the act, you got them on robbery, you potentially got them on kidnapping. What's this offense designed to capture?
it is to capture just what you're saying.
So I pulled these dudes over.
So can I give you an example of Galveston?
Please.
So in Galveston, we had a case where there were 2 people in a vehicle, rented vehicle, out-of-state license plate, the dark tint you could not even see in. They back into a parking spot because they usually want to face the bank. They sit there for hours, no one getting out of the vehicle and going inside the bank or coming from the bank. And they're watching people. And even there's times where they like pull out and change spots. They spot someone. They start to follow that person. So law enforcement usually, like he said, they're staking out the bank. So they're watching this behavior. Now, the following, it's not just following someone. A lot of the times in our case, the person gets out in front of them, so they have to drive 80, 90 miles on the highway. They start cutting people off because they have to get back behind the vehicle. Then when they do get behind the vehicle, they slow down. Then they follow that vehicle, and they can follow you all the way to the house, where for us in League City, they actually did follow someone, and they robbed him in his garage, and they killed him. Now, that was a capital murder, and we did prosecute that case. But we are trying to stop it before. So in this particular case, the officers see all this behavior, all the driving facts. They run the license plate of the victim that they're following and see that they're 1 mile from their house. Law enforcement doesn't want to wait until they get to that person's house, so they pull them over.
Okay, so you pull them over, and ideally, what objects do you want to be able to have in the vehicle so that you know you satisfy the elements of the offense?
Yes, sir. And so in this particular case, and we've had more than one case of it, it's zip ties sometimes, duct tape, mask, the screwdriver, different license plates, the window punch. So when you start thinking about those things, a window punch isn't altered. You don't need to alter it. The mask is to conceal you. You don't need to do anything to it.
My suggestion, Ms. Allen, is that we get a committee sub with those specific items identified in the statute, because referencing it back to 1601, 1601 is designed to capture a totally different criminal activity than what's entertained by this statute. So if you got some particular items, I mean, the zip ties or duct tape is to bind someone, right?
It could be, yes.
Okay. So when you've got those items, my suggestion would be that we get those specific items into the statute so that there's not a question about vagueness, because I flipped over to 1601, I went, what the heck is that? And I know a defense lawyer is going to do that too. So,
And I think one way to maybe solve it is just the definition change and change it to say means anything that in the manner of its use or intended use is capable of affecting the commission of the offense.
something more specific than that. I'm thinking items that could be used to bind a victim, items that could be used to break glass. I'm not the draftsman. I could play one on TV, but I just think that there's probably a narrower way that we could get at this topic. That's all for me, Chairman.
Thank you. Members, any other questions? Thank you.
Thank you.
Chair calls Celeste Embray. We show you registered as Celeste Embray from the Texas Bankers Association.
That's correct,
Are you
yes.
on, for, or against the bill?
I'm for the bill.
Thank you.
Sure. My name is Celeste Embry. I'm the General Counsel of the Texas Bankers Association. I am here testifying in strong support of this bill. Jugging has become a huge problem for Texas banks. We represent approximately 400 at TBA, and we have seen an increase in this type of behavior, especially since the beginning of the pandemic. I have data showing just from one bank how often these crimes are occurring. We have screen captures from surveillance video about bank customers being harmed during the commission of this crime. And so we're very, very appreciative of Representative Cook and the law enforcement that's here supporting Texas banks. I'm happy to answer any questions that you may have. Otherwise, I'll just say we support the bill.
Member, do we have any questions? No, thank you.
Thank you.
Chair calls Sylvia Escobedo.
Good afternoon. I'm Sylvia Escobedo. I'm here to testify in support of this House Bill number 1902. I am for it, and I'm testifying on behalf of myself.
Testifying for self. Sylvia Escobedo, attorney. Go ahead. Thank you.
Go ahead. Okay. Thank you. I became interested in this bill. I was a victim of jugging a few weeks ago, and I was here before the committee briefly on another issue a couple weeks ago, and I wanted to come back and address this some more, and I have sent some information to Representative Cook's staff prior to today, some of which he's already implemented in his sub. I haven't read the text of the sub. I'm in support of this bill for several reasons. I also have some of the concerns that Representative Little and Representative Money have laid out, because I have been a criminal defense attorney for 16 years. So I would really like to see the substance of the bill, and offline I could perhaps assist, because the adding the additional elements of the two instruments, criminal instruments, is absolutely going to be a field day for me as a defense attorney to attack. They're not going to be able to prove that. It's way too vague. The reason that, and I was a prosecutor for 14 years, so now I'm a victim, and I'm here speaking as a victim, but I have the benefit of seeing this, how it will practically be executed in the court of law. So as a victim, that's my concern, because this took a lot of effort on behalf of the representatives to get us this far, and everyone that's here. So I just want to make sure we close any gaps. And like it does talk about enhancing, if it's a BMV, that in the course of a BMV that makes it a third degree, and it talks about enhancing when it in the commission of a robbery, which makes it then a first degree instead of a second degree. But it doesn't talk about what if it's in the commission of a theft from person, which would be normally a state jail felony, but then if you were to enhance that, then that would be a third degree. So there's a bunch of different ways this can kind of go. The reason that this is so important in my particular case, in dealing with the auto crimes task force, everything that you've heard today is pretty much on par with what happened in my case, but mine was from a retail establishment, not from a bank. They rented a car. They stole a license plate off a similar vehicle that looked like that car. All of the information on the rental forms at the rental car place were fictitious. The address they gave to rent the car was fictitious. The driver's license they had was fictitious. They determined they had a burner phone that they had purchased 2 days beforehand, so that phone no longer exists. They switched the license plates, drove to the Galleria, targeted me. Who knows who else was targeted. And then within a day, the rental car was returned back to the rental place. So this is happening a lot in Houston, and as the officers and the prosecutor have already spoke on, it is something very serious needs to be done, and that's why I would like to thank all of the representatives that are here today for hearing me and understanding how very important it is. As a criminal defense attorney, I obviously don't want to be just adding laws to the penal code. And when I had first reviewed this with my colleagues on the criminal defense side, that was their first thing was, why would they do this? Because we already have the crimes of burglary of a motor vehicle and robbery and aggravated robbery. This seems like it's needless. But now hearing the background of why they want to put this in the books, and then not only to deter and be able to intercept these crimes before they're committed, but to also then enhance the penalties if they are committed. So I would applaud Representative Cook and all of his staff and his hard work and everybody who has been a part of this. I'm very strongly in support of this. And if you have any questions, I would like to answer them.
Thank you. Members, are there any questions? Ms. Witness? Thank you.
Thank you for your time.
Chair calls April Aguirre. Registered as April Aguirre.
Yes,
Especially for yourself.
that's right.
On, for, or against the bill?
I'm for the bill.
Thank you.
The only thing that I would ask is that we find a way to really strengthen it. I'm going to read you some numbers here that was quoted from the Houston Chronicle. In 2022, there was a total, in 2021, there was a total of 850 jugging incidents that were tried. So people that were actually charged. When I think about this number, I think about how many weren't caught or how many were not reported, right? In moving forward to 2022, there were 715 incidents. Right now, there's no numbers for Houston-Harris County for 2023 or 2024. We're still waiting on those. So my point is that it's happening, and it's happening a lot. And the neighboring counties in our community are seeing that criminals from Harris County and Houston are moving and are committing these crimes in other areas of the state. I am just in disbelief that right now our penal code does not address this, and we are falling behind and not catching up with the way criminals are evolving. This is their job. They wake up, they find a way to victimize people. And it's just so devastating that you work so hard, and there's just some videos here from the HPD robbery website of wanted fugitives, of what they do. Prosecutors are struggling. They're struggling to charge these people because they don't have the tools. And there's just so much of it going on. To me, it's just common sense, right? However, it does need strengthening. Our prosecutors need the tools, and our police officers need the tools. At the very least, for that day, they can stop the jugging from happening that particular day. And there's a very sad incident where a lady was planning to go back to Vietnam after 20 years of working in this country. She pulled out money, and she was left paralyzed in the incident. Paralyzed. And I will pull up that video for you. It's one that I resonate with because
I understand how hard people work for their money. She was dropped to the ground. This guy did not have a gun, but just his person, it was violent enough. And for moving forward, she is paralyzed. But I just want to bring it to your attention, the numbers are staggering. And I look forward to the 2023 and 2024 numbers to come out. I appreciate your time and working with Cook to strengthen this, and let's give them the tools they need so they can address this. Thank you very much.
Thank you. Members, are there any questions for the witness?
Thank you.
Thank you. Thank you very much. Chair calls Eric Carcerano. You're registered, sir, as Eric Carcerano, Chambers County District Attorney and self. Is this correct?
Yes, sir.
Thank you. And you're on for or against the bill?
Testifying for the bill,
Thank you.
Mr. Chairman. Yes, sir, Mr. Chairman. I was initially going to get up and talk about law of parties, but my colleague, Ms. Allen, handled that very well. But I wanted to specifically address some of the concerns that Representative Little had concerning the definitions in the bill. If we get too specific with what we're going to call a criminal instrument, I think the end result of that will be that the criminals will just stop carrying those specific items in their vehicles, on their persons, and that kind of defeats the purpose. And I think probably a better approach would be if you look at the definition of a deadly weapon in the penal code, the definition of a deadly weapon is anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. That's been the definition for a long time. It's been challenged. It's not vague. That's the definition that every prosecutor in the state uses to define a deadly weapon. I think in this particular situation, we could adapt something along those lines in the bill to define what we're going to call a criminal instrument. So we could say anything that in the manner of its use or intended use is used, something along those lines, that we have an instrument, something that has normal everyday use, but in this particular instance is used to commit this offense. And I think that's probably the best way to go on this. Because if you take a definition like that, it's not too vague. Everybody knows what the definition of a deadly weapon is in the state of Texas. And I think if you adapt something with that language to a criminal instrument, you're not going to have any problems with this statute.
Thank you. Members, any questions for this witness?
Just very briefly.
Representative Money.
Thank you, Chairman. The place where I'm struggling is hearing these other witnesses testify. In other cases, there was no deadly weapon. There's objects that were used to, there were zip ties, duct tape, glass breaker. None of those are deadly weapons. And so it's like almost going too far that direction, you don't capture all the people who are just going to pull somebody out of their car and beat the hell out of them. So tell me what to do.
And I may have misstated what I was trying to get across in my. I don't think that we need to use the definition of a deadly weapon. My point is we need to take the language of the deadly weapon definition and adapt that language to criminal instruments. So we could say anything that in its manner, in the manner of its use or intended use, is used in committing the offense, something along those lines. And that we can figure out that language. But if you, in this particular instance, a deadly weapon, there was an article in the Texas Prosecutor a few years ago that kind of talked about frogs being deadly weapons. You can rub a frog on somebody and poison them and kill them. And that's obviously the far. But there are things in our everyday lives that we can use to hurt people with that are considered deadly weapons under the statute.
Yeah.
And I think that's where we need to go with this definition.
I see your problem. I hope that the DAs who are going to be using the statute can figure out a way to make it constitutionally sound, because I look at that other definition, I just don't know what to do with it.
And I think we're looking forward to working with Chair Cook to get this straightened out.
If anybody will get it figured out, he will.
Thank you, sir. Any other questions?
Thank you. Members, any other questions for this witness? Is there anyone else who wishes to testify on, for, or against House Bill 1902? If not, the chair recognizes Chairman Cook to close on the bill.
Thank you, Chairman. Appreciate the opportunity to lay out this bill. Appreciate the positive feedback. Good points being made here. I too struggled with that definition, Mitch, when I received it as a suggestion. I think there's been a lot of good discussions today. And to your point, this is the criminal laws of Texas book that I think the Texas District and County Attorneys Association uses. And even in here, in defining criminal instruments, there's different, I guess, court cases, and our job as legislature is try to, set the intent and set, make it very clear what the definitions are. And so, great feedback, and I'll definitely work with you and anyone who wants to work on it. But we'll make sure that we get the definition cleaned up and then get it to the full committee, and would appreciate your favorable consideration. And I close if there's no other questions.
Thank you, Chair Cook. If there's no objection, the bill will be left pending. We are going to have to, where is it? The committee substitute amendment is withdrawn. If there is no objection, the bill will be left pending.
Thank you, Chairman.
Thank you. The House Bill 1902 is left pending. Okay. Now we're going to lay out. The chair lays out House Bill 1789. House Bill 1789. Recognize Representative Gertis to explain the bill.
Thank you, Mr. Chairman, members, for the opportunity to present House Bill 1789. This bill is a refile of Senator Colcourt's SB 726 from last session, a bill that passed out of the Senate and House Committee last session unanimously. It provides additional sentencing option for prosecutors by creating a new first-degree felony offense for intoxication manslaughter for defendants who caused the death of more than one individual. This bill is based on a case from 2020 involving 4 victims, including a 6-year-old and 2 18-year-olds. At the time of the collision that caused their deaths, the defendant was intoxicated and was cited for driving more than 90 miles per hour near Lake Somerville. The defendant pled to 20 years, the maximum punishment for all 4 victims, in an effort to avoid going to trial and allowing the judge to stack the sentences. There have been cases in which multiple individuals have been killed by a drunk driver who received the maximum sentence for 1 count. In those instances, the families of the victims have advocated for changes to the sentencing structure for those charged with multiple counts of intoxication manslaughter. And HB 1789 seeks to address those concerns. Thank you, Mr. Chairman and members. I'm happy to take any questions and would like to reserve my right to close.
Members, are there any questions for Representative Gertis?
Just one.
Representative Little.
Chairman Louderback, thank you. Representative Gertis, is an unborn baby a person under this statute? So the question I ask is, I ask the question because it says an offense is felony of the first degree if it's shown on the trial of the offense the person caused the death of, in your additional language, is more than one person during the same criminal transaction. It's designed to capture the situation where we have an unborn baby.
Well, unborn baby is a person.
Better be.
Yep. That's right.
All right. Thank you.
Is there any questions for Representative Gertis? Thank you.
Thank you.
If there are no further questions, the chair will call the first witness. We have Eric Carcerano. Chambers County District Attorney, Mr. Eric Carcerano, and self.
Yes, sir.
Thank you, sir. Testifying on, for, or against?
Testifying in favor.
Thank you.
Thank you, Mr. Chairman, members of the committee. My name is Eric Carcerano. I'm an assistant DA in Chambers County. I'm board certified in criminal law and criminal appeals, been practicing law for about 31 years. We did a lot of work on this bill last session, just couldn't get it across the finish line. The companion was heard in the Senate this week and has already been referred to local in consent. These cases are already difficult to prosecute as they are, but the way the current sentencing structure is set up on a second-degree felony, the punishment is 2 years to 20 years, and the judge is the only one who has the option to stack those sentences. Otherwise, by law, they're all required to run concurrently. This bill gives the prosecutors another sentencing option where you have cases where there is more than one fatality. Sadly, we have more of these cases than we care to talk about in Chambers County because we have this long and windy road that goes from the interstate to the beach, and it's dark at night, and that's where all of our accidents occur. We had an accident about 3 years ago where, same thing, we had 2 fatalities come from an accident. The jury decided to give the defendant penitentiary time on one of the deaths and probation on the other death. Don't ask me why. I don't try to predict what juries do. But in this particular instance, this bill will give prosecutors another tool to be able to sentence these cases as appropriate. And I think it's important to note that even though this will make a first-degree felony, obviously 5 to 99 as opposed to 2 to 20, there's nothing in this bill mandatory that says you need to go more than 20 on these cases. If you want to sentence somebody to 20 years on multiple deaths, you can still do that under this bill, and I'll be glad to answer any questions.
Members, are there any questions for this witness?
Thank you,
sir. Is there anyone else who'd like to testify on, for, or against House Bill 1789? If not, the chair recognizes Representative Gertis to close on the bill.
Thank you, members. And if there's no more questions, I close.
Okay. Thank you, Representative Gertis. If there's no objection, the bill will be left pending.
Thank you.
Okay, yeah. Let's see, what do we got? Yeah, we got. The chair lays out House Bill 1713, House Bill 1713, and recognizes Representative Placer to explain the bill.
Thank you so much, Mr. Chairman Louderback and members of the committee, for allowing me to lay out House Bill 1713 before you today. House Bill 1713 establishes stronger protections against EV charger tampering, safeguarding critical infrastructure and ensuring Texas driving electric vehicles can do so confidently, even at far-from-home charging stations. According to the Texas Department of Transportation, Texas has more than 300,000 registered electric vehicles and 4,300 public charging stations. As EV adoption grows, more Texans will rely on accessibility and secure charging network. However, tampering with EV chargers is a growing problem nationwide. EV charging stations across the country are being deliberately damaged or vandalized. Charging tampering not only results in costly damages for both retailers and vehicle owners, but also creates a public safety risk. These stations deliver high voltage electricity, and improper interference can lead to fires, electrical failures, and even electrocution. Sorry. By classifying EV charger tampering as a third-degree felony, this bill creates a strong deterrent against such actions, ensuring that safety and reliability of Texas's charging infrastructure. This bill creates a public safety precautions for a pioneering industry, and Texas has the opportunity to lead the nation in securing this critical infrastructure. House Bill 1713 provides security for EV users, protects businesses from financial loss, and protects further investment in the state's growing EV industry. Thank you so much for your attention today. I do have some witnesses here that can further elaborate on what their experiences have been with this type of tampering, and I'm happy to answer any questions you guys might have and reserve the right to close.
Thank you. Members, are there any questions for Representative Placer?
No? Okay.
Thank you.
Thank you.
Chair calls David D'Angelo. And you're registered as David D'Angelo from Racetrack, Inc.
Yes, sir. And registering for the bill.
For the bill.
Chair
Thank you.
Louderback, well, congratulations on your first day chairing a committee. I know it's been a long one, so I'll be
It's
brief.
been fun.
Members of the committee.
Great committee.
Thank you for holding today's hearing, and thank you, Rep. Plessa, for introducing the bill. As I said, my name is David D'Angelo, and I'm testifying in support of HB 1713 on behalf of Racetrack. Headquartered in Atlanta, Georgia, Racetrack operates over 800 convenience stores and employs over 12,000 team members across 14 states. In Texas, Racetrack operates 137 stores, including franchise-operated raceway stores, and employs approximately 1,800 people. At the stores, whether you come to grab a cup of coffee, which, if I might say, is the best in the industry, no offense to anyone else, or refuel your vehicle, we are committed to making people's lives simpler and more enjoyable. This means meeting the demands of our guests by retailing legally permissible fuels such as gasoline, diesel, ethanol, and electricity. Racetrack, to be clear, is fuel agnostic, and to meet the growing demand for electric fueling, the company began operating 5 EV charging stations in 2024 across the Texas footprint. But I want to be clear, we are happy to retail diesel and any other liquid fuel if it is legally permissible and folks want it. However, installing and operating EV charging stations represent...
Sir, you stay on the bill, please. Stay on the bill.
Oh, my apologies, sir. Installing and operating EV charging stations represent an investment by the company, and the intentional destruction or tampering with these or any other fuel dispensers comes with the cost, both financial and reputational, to the company. Racetrack's highest priority is ensuring the safety of its team members working at our stores, but close to that is safeguarding the property, including all of our fuel dispensers. It is far harder to do so, however, because business that we operate relies upon the public having easy and ready access to get to them. This makes them singularly vulnerable to anyone seeking to inflict damage, which, as the representative said, has been occurring nationwide. HB 1713 would place the penalty for tampering with EV chargers on the same level as other property crimes and is commiserate to the cost for replacing the damage done in these instances. That is all I have, and I'm happy to answer any questions the committee has at this time.
Members, any questions for the witness? Representative Money.
What kind of, it says wholly or partly impairment, causes wholly or partly impairment or disruption to electric vehicle supply equipment. What kind of problems are you seeing that you think this would address?
Of course, thank you for the question, sir. That can entail something as simple as someone cutting a cable, but what we have in mind, and the one that this really gets at, is individuals seeking to steal the copper wiring from the unit and then selling it on the black market. Because folks think that, oh, there's going to be a lot of copper wire, I can make a lot of money. There's only roughly about $20 to $25 worth of copper wire in each unit. But to get to that, you have to really tear into that machine. And by doing so, you are inflicting severe damage that is not necessarily easy to repair or without its significant costs.
Okay, and so how much do one of those charging stations cost?
So
installed?
So thank you, sir. So to be clear, these are the level 3, the DCF fast chargers. These are the ones that will get a vehicle fueled roughly 20 minutes to 80%. So we're trying in the C-store industry to model the liquid fuel experience where you're done in 3 minutes. So DCF fast ones, which we offer, those are the very expensive ones. You know, they can run up to $100,000.
Okay, so if someone destroys that, like we're talking about, that would already be a felony of the third degree, because the amount of the pecuniary loss is 30,000 or more, but less than 150,000. I'm just concerned. This says the actor causes wholly or partly impairment or disruption to electric vehicle supply equipment. I'm just not sure exactly what all that entails. If I park in front of it when somebody else wants to use it, if I, partial impairment, disruption is different than destruction. And your stores have. You probably don't have to deal with it because you got employees there 24 hours a day, but you got a lot of places where people will go destroy HVAC equipment for the same reason, same purpose. And so to take all the copper out of it, and it's not that much, but it costs tens of thousands of dollars to replace. And those are, at least for, I'm not saying for everything that Representative Plessa is trying to resolve, but at least for your issue, it seemed to be similar to that. And though that should already be handled with, I would think, I have to look at the rest of this, but you're still talking about a large monetary damage to you that would be covered already by the penal code.
It depends, because they're not going to know the assessment until they've witnessed it. They've run diagnostics. It could be 20,000. It could be 100,000. This is modeled very closely after previous bills and current bills by Chair Leach and in the Senate by Senator Betancourt for liquid fuel pumps, which we also support. So that language is exactly similar to that. And I would have thought several years ago that there is no need for this type of law, but apparently there is. And like I said, we support it. And EV charging equipment is far more expensive to replace than a fuel pump. But to your
Sir, you have to stay on this bill, no other bills.
Apologies, Chairman. To your point, sir, this is envisioning the, intentional destruction of the property, not necessarily parking in a space.
Okay, thank you.
Members, are there any other questions for this witness? Thank you, sir.
Thank you, Chairman.
Chair calls Jill Warren.
Thank you, Mr. Chairman. My name is Jill Warren. Thank you for the opportunity to testify today in favor of House Bill 1713 on behalf as outside counsel to Electrify America. Electrify America is a company dedicated to building and operating direct current fast chargers for electric vehicles across the nation. In Texas, Electrify America has 180 chargers across 38 stations with more underway. And we express our strong support for House Bill 1713, which sets the criminal penalty for vandalizing EV charging stations at a third-degree felony. Vandalism, specifically cable cutting, has become a persistent and costly problem for our network. Individuals cut and steal charging cables, likely for their scrap metal value, and the damage creates disproportionately negative impacts on the infrastructure and the emerging industry's economics. A single act of vandalism can cost between $200,000 and $10,000, and replacement parts are not often readily available. These criminal acts disrupt the station's operations, frustrate drivers, and erode public confidence in the infrastructure. The organized crime element often returns to the scene within 24 to 48 hours after repair because the prosecution deterrent is not there. Direct current fast chargers are almost always co-located with retailers who benefit from the foot traffic induced by the charging station. When chargers are vandalized, these businesses lose their customers and are burdened with the poor optics of having inoperable infrastructure in their parking facilities. The EV charging industry has worked with retailers to curb vandalism by increasing lighting, installing security cameras, but these measures alone are not enough. Stronger penalties are necessary to protect companies' investments in Texas and to ensure that this infrastructure remains in a good state of repair. This criminal penalty, to answer Mr. Money's question, mirrors those for retail motor fuel pumps and electric
vehicle charging stations found in Senate Bill 988 by Betancourt that passed the Senate last week 29-2 and was received in the House this week. It puts in parity tampering with power supply infrastructure that brings down an entire system. So the pecuniary loss might be a smaller amount, to answer your question, but the cascading effect of bringing down the infrastructure is what has caused power supply infrastructure, motor fuel pumps, and then now EV charging stations to be in the mix for that enhancement of a penalty.
Can you give me I'm sorry.
Go ahead. Oh, I just
Thank
had
you.
one sentence left, so go ahead.
Have any questions for this witness?
I apologize, Mr. Chairman. I'm used to being on city council where you just interrupt and ask whatever you want.
Representative Money.
Well, I'm an appellate lawyer, so I always try to wait for the judge.
Yeah. What was the Senate bill number that you were talking
It's
about?
988. It just passed the Senate last week. It was a motor fuel pump bill by Betancourt, and Senator Huffman added the EV charging station language.
We need to stay on this bill.
Okay.
And any reference to any other bills.
That's my fault.
That's
I
okay.
apologize.
Anyway, that is what we're trying to do is put fuel pumps, motor fuel pumps, and EV charging stations in parity in the law, and there's opportunities to do that in this bill and others in the legislature this session. In conclusion, passing this bill will take an important step toward deterring the criminal activity that's really impairing this infrastructure throughout the state and will only continue to grow and promote the organized crime element that's out there already.
Understood.
Thank you for your time today. If you have any questions.
Members, are there any questions for this witness? No, thank you.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 1713? If not, the chair recognizes Representative Plesa.
Thank you so much,
Close
Chairman.
on the bill.
Thank you so much, Chairman Lauterbach, and members, for the opportunity to present this bill before you today and for your time considering the need to protect Texas's EV charging infrastructure. Just to give you another statistic, Representative Money, 20% of our EV infrastructure, our charging stations, have seen this type of crime. And what happens is, look, my husband just recently bought an EV, a Rivian. And what I found out is that when you put in your designation, it will show you all of the charging points between where you are and the place that you're going. And if there's any interruption, right, if there's an EV charging point that's down or has been tampered with, it takes a while for them to come back up. So that's going to affect the travel time. It's going to affect how you get to your next location. So that's all that this is trying to do, is deter individuals from going up to those machines, breaking them open, trying to get copper out, cutting the cords because they can be used as like converter between EVs. And so that's all this is trying to do, is bring our fuel and motor pumps to the same level as, or bring our EV pumps to the same level as our fuel and motor pumps. And with that, I'll take any questions and close.
Thank you, Representative Plesa. You have questions?
Thank you, Chairman and members.
If there is no objection, the bill will be left pending. Yes, on, what is it, 1713, House Bill 1713. If there's no objection, the bill will be left pending. If the chair hears none, then House Bill 1713 is left pending. Okay, the chair lays out House Bill 2666 and recognizes Representative Riddell to explain the bill.
Thank you, Chairman Lauterbach. It's the first time I've got to say that.
Thank you.
House Bill 2666 is a very simple bill. We're just adding one element into the current code. So currently, if you burn down something, it's a second-degree felony, unless it meets one of currently two criteria. It's either a habitation or a place of assembly or worship, and then that elevates it to a first degree. So I believe it was 2021 in Mason County, where I go to church and spend a lot of my personal time. Gentleman that I actually went to high school with had burned down the courthouse. mental illness, whatever you want to call it, burned down the courthouse. And he unfortunately, in the code, because government building is not listed in here as a reason to charge with first degree, he could only be charged with second degree on that. It cost $20 million to rebuild that courthouse. And so all we're doing is just elevating this. We're adding government building into the code that allows you to pursue first degree felony instead. And I think I've covered everything. Do y'all have any questions for me?
Members, are there any questions for Representative Riddell?
No? All right.
No questions.
I don't think there's, I'll step down for a minute, but if there's no one else to testify, I'll just go ahead and close on that too. So, thank you.
Thank you. There's anyone else who wishes to testify on, for, or against House Bill 2666? If not, the chair recognizes Representative Riddell to close on the bill.
With that, I close. Thank y'all for y'all's time. Hope y'all have a good weekend. So.
Thank you. Thank you, Representative Riddell.
Chairman Lauterbach, I have a motion.
Okay.
Go ahead. Chairman Lauterbach, I have a motion.
Thank you, Representative Little. Put it on record. Yeah. I move in writing to a favor. Oh, we gotta go here. Okay. Following motion in writing by Representative Little. Do you want to read this?
Did you leave it pending before you read the motion? If not, leave it pending and then you can do the motion. I'm sorry. We're trying not to go out of order. So leave House Bill 266 pending, and then you can make that motion.
We're going to leave House Bill 2666 pending and entertain the motion.
Was there any objection to leaving it pending?
Yeah. Is there any offense for the motion impending?
No objection.
No objection. Okay. Hearing none, the motion.
Hearing none, the bill is left pending.
Hearing none, the bill is left pending. Oh, yeah, left pending. The following motion in writing by Representative Little. I move that the subcommittee chair inform the committee chair that the subcommittee has completed its deliberation and recommends that Bill HB 2666 be scheduled for consideration by the full committee. The question occurs on the adoption of the motion. Clerk will call the roll.
Chair Lauterbach,
Okay.
Representative Bowers, Representative Little,
Aye.
Representative Money,
Aye.
Representative Moody. 3 present, 2 absent.
There being 3 ayes, 2 absences, the motion prevails.
All right. Thank y'all. Appreciate it. Thank you.
Now, what you need to do, so, you need to read. So, you'll need to read this for 2695, and then you can adjourn.
Members, for House Bill 2695, at the author's request, we will not be considering House Bill 2695 today. The chair moves that the committee stand in recess until final adjournment. Members, that concludes today's agenda. Is there any further business for the committee to address? If not, the chair moves to adjourn. Is there an objection? Hearing none, the committee stands adjourned, subject to the call of the chair.